Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How are you guys doing? I am not late. I am on time. I am precisely on time. This is discrimination. I'm just kidding. I'm back. Oh my gosh. So anyway, we're here. Today has been an interesting day. Oh my goodness. I'm old. We've got some stuff to do tonight, of course. We had Ethan Van Skyver versus Pegston Poulter, but the judge just ruled on Kiwi Farms versus Greer. So I was thinking, I'm just kidding. I'm not actually going to cancel and do Kiwi Farms versus Greer. We've got tomorrow. Set up for that will be fine. We are doing Ethan Van Skyver and DA Talks versus Pegston, Peggy the sore sphincter Poulter. And we will be going through documents. We will be digging into what's going on here. This is going to be maybe a little bit legal intense for the episode. For this law show, we're going to do some law lickery-loos. There's a bunch of other stuff also happening in the world. And as I procrastinate and stall for a little bit and let people filter in and get the document back up, since my computer decided to shut down, even though I had the documents up, but now I will get them back. There's other stuff going on in the world right now. One of the big news story today, Gabby Petito has been positively identified as dead, and they have ruled the cause of death to be a homicide. That's the sort of status that we know right now, is that they believe it is a homicide. Though it is still not a murder investigation, it is a homicide, which just means that she was killed by a homo sapiens. And we don't know exactly what the circumstances of the homicide are, but looks to me like Gabby Petito was murdered, and I'm still going with potentially partially eaten by her boyfriend, because I'm hoping that sticks. Quartering just peed in his basement. Thank you, Jeremy, for that live update. Very important to know. Oh yes, I will explain. We will do some backstory on EVS versus Peggy Poulter, so that people know who we're talking about. But yeah, so for what it's worth, Brian Laundrie, the boyfriend of Gabby Petito and likely slayer, is nowhere to be found presently. There was a trail camera that happened to capture an image that some people think might have been him. I think that was in Georgia. If he's walking from Florida to Georgia, I mean, that's a long way. But he has been missing for 7 days now, and it'll be pretty interesting to see what's up. The one other thing in Gabby Petito's case that has kind of hit the news today that I saw is that her last text message was revealed. The last text message that she sent to her mom that her parents did not believe came from her was revealed. It was a little bit weird. It basically said, "Can you help out Stan?" or something like that. I keep missing his calls and messages. Stan is allegedly the name of Gabby's grandfather. However, no one calls him by the name Stan. So I don't know if the thinking is that Stan kept showing up in notifications and the boyfriend, presumably with blood all over his hands and mouth, picked up her phone and texted to the mom to, like, can you help out with Stan, not knowing that was her grandfather. Or if she was sending the message to her mom using a sort of coded message, like, using the wrong name for someone to indicate that she was not okay if her phone was being monitored. Don't really know what the scoop is there. What we do know is that her parents do not believe that she sent that text message. So that is that. That is the Gabby Petito update. And just kind of looking for some, I think it'll be an interesting murder charge on the guy when we find out a little bit more. We don't know cause of death yet, no. Next, I took a shot on Twitter today. Jack Murphy asked who he should interview on his podcast, and I dropped a comment that said, hey, Jack, would love to chat sometime. Your show or mine would be great. And he responded that he would be interested in setting up a show. So I've dropped him a DM, and if it works out, it works out, and that would be very cool. I would love to talk to Jack and get to know him a little bit, and so that might happen. That might happen, and I think it would be a good chat. So there's that. I don't know what else is going on. Devin Nunes is out here trying to rewrite defamation law, which is pretty interesting, forcing a showdown on New York Times versus Sullivan. Some people have some hypothesis that Nunes will be involved in some way, that the Nunes decision would have some sort of impact on Vic's case. I don't think that's going to be a thing, frankly, because it'll be a long time before the Nunes thing is decided. But really interesting sort of defamation scenario where Nunes sued someone for defamation. They basically won because they said under New York Times versus Sullivan, there's no actual malice, therefore there's no defamation. Then afterwards, the same person retweeted their tweet with a comment and a link to the original article that they wrote. Now, normally in defamation cases, you have something called the single publication rule, which if you, the original publication itself being published can't be litigated multiple times because you don't want to be able to sue someone for every book sale, right? If there's defamation in the book, you get to sue over the defamation of the book. You don't get to sue every time it's sold. But they ruled that, in this case, the retweet with a new comment attached to it counted as a republication against the single publication rule. And now Devin Nunes' suit against this person will get to go on because the court said now the person has notice that Devin Nunes has denied the allegations, which is really interesting because if you, again, pay attention to law Twitter, merely denying the allegations is not sufficient, and anyone who denies the allegations, that doesn't make anything defamatory or even a jury question, and why don't you just shoot yourself in the head, they would say. But as it turns out, reality of how courts work is different than what law Twitter wants it to be, and so with that, we see some interesting possibilities for Devin Nunes. But will it filter down to Vic? I don't think so. I don't think the Nunes case will have anything to say about it at all. Jeremy from the Quartering says, listen, millionaires, just buy a farm and deprive your children of everything because Tim Pool said so. There's no amount of suffering Tim will volunteer his viewers for. Yes, that is my one-sided fight with Tim Pool, the chicken whisperer, or chicken melodist. I don't know. Strumming that guitar. I gotta pull up the chicken art, right? I've got to do that. It's amazing. People are very interesting because I talked about it. I thought it would be useful for a conversation about principles and this vaccine stuff in general. And people have turned that into, one, I'm jealous of Tim Pool, and two, I'm mad at Tim Pool. Neither of those things are true. Jealousy is a weird thing that I don't know if people understand. And I'm not making the distinction between jealousy and envy here. Tim Pool has a very successful show, and I wish him all of the success in the world. Would I love to have his viewers and revenue? Sure, of course. But it's not like I'm jealous of them. I'm working towards them. I see the success of his show as, the possibility that mine can keep growing and improving. And I think I'm funnier and have more hair. And I'm also taller. So, I mean, all of those things are going for me. But here's the most important thing. So last night, my internet went down, but I was able to access, Twitter through my phone. And I tweeted out a tweet that said, my dad always told me to find a girl who will play guitar for you like Tim Pool plays guitar for his chickens. Because I thought it was funny because I'd had a couple drinks. Now that I haven't been drinking, it's not as funny, but this makes it better. Zevius drew it last night, and it was amazing. I love this thing. It was so good. It's such a good drawing, and Zevius is a fantastically talented artist who put this together overnight. So props to him. That's a piece of work. It's really, really terrific. So anyway, I wanted to share that with you guys. Because see, that's something I can never do. I can't draw to save your life or mine or anybody else's. I'm not an art in that way, in really any way. If you want to see examples of my art, it's shitty MS Paint work on thumbnails. Like that's it. That's the extent of it. So I wish I could do stuff like that. It is so cool to me that people can put that type of stuff together. But I will just sit here jealous of Zevius much more than jealous of Tim Pool. Franco Miranda says, how's it going, Nick? I don't know if you've covered this, but Jay Sean Lemoyne was interviewed on the Lawyer Show a few days ago. You can tell during the interview that Vic and the GoFundMe are still on his mind. Of course they are. And importantly, Jay Sean Lemoyne. And I only bring this up because the law Twitter simps would shit on me for it. He forgot to mention actual malice as sort of a standard in defamation cases of public figures. I have not watched the whole interview because I don't know if I can sit through his gargly, wheezy, horrific voice. But maybe I should watch it and see if there are any excerpts worth talking about. I don't know. Jay Sean is a weirdo. He could be defeated by a flight of stairs. So I'm not, I don't know how much time I want to spend on it. That's true. My Muhammad drawing is very, very good. It is very, very good. I should not lie. That was pretty. It's at the Met now. It's at the Met, and humble brag, but yeah. Jay Sean Lemoyne was the lawyer representing Monica Rial and Ron Toye against Vic. So, for those who aren't familiar with names that I just casually throw around that literally don't matter outside of this tiny sphere of the internet in which we live and laugh and meme. Oh my goodness. This is the last of my Redwood Empire. This is all I have left of the Redwood Empire. Okay. Trying to think of the last other things. I mentioned Russell Greer has lost his lawsuit against the Kiwi farms, which is very, very big news. That one we've been watching for a while, waiting for a decision. The judge issued a 13-page opinion. We will probably get to it tomorrow. We will probably not get to it today. I don't know if he is going to appeal like Melinda Scott appealed her case, but we'll have to just see. I also probably should update on the Critical K lawsuit at some point. There's been some filings and stuff in that lawsuit. Also, I have it on good authority that the Critical K referred to the lawyer suing her as a man baby, which is kind of funny to me. And I, for one, when I, will never think of him as anything other than a man baby. He's a great guy and by many accounts a very good lawyer. But I just thought it was funny that she called him a man baby. That made me laugh. And I got to give credit where it's due. I think she also called him a bitch baby, which isn't as funny. Man baby's funny. Bitch baby is less funny. Ralph Josh did have to hire an attorney for each suit. For the suit against Melinda Scott, he hired Matthew Harden. And then for the suit against Russell Greer, he hired Greer's arch nemesis, Gregory Skordis. And, both were successful. I do not know if he will be getting any sort of compensation back from either party. He's moving for fees against Melinda Scott, but Melinda Scott is also, he's moving for an appeal bond. I don't know if he's moving for fees or not, but Melinda Scott and Russell Greer are both destitute. So who knows if he will be able to recover anything out of them. I'm sure if Russell Greer were to sell his drool as, what's her face sold her bathwater, then maybe maybe that would work. Maybe he could raise the funds. Is it weird to anybody else? I can't remember the chick who sold her bathwater. What was her name? Belle Delphine. There you go. I can't remember. Where'd she go? Belle Delphine has basically disappeared from the social media radar. Did she quit? What happened? I know she. I say who cares because it's interesting because she was the OnlyFans meta, right? Like she was the OnlyFans poster child, and then she just no longer is talked about. She got unpersoned. Other thoughts came up and rised up in her place, and now they don't talk about Belle Delphine anymore. I just found that interesting. She does. I keep seeing a lot that she does actual porn now. Yeah, that's fine or whatever. But I just found it weird that I don't see any news story. Because look, I get thought news, right? My Google News app feeds me thought news, like this the stupid website Dexerto, which covers Twitch thoughtery, and all things Twitch. But there's the new Twitch chick, or she's not new, but she did the new thing. She's now speed dating the simps. You join her Discord and then you get a 7-minute speed date with her or something. That's the new news story. And guys, if you are speed dating a Twitch thought, consider speed dating a Cliff. Try that one. Just do that. It's probably less dangerous. But she's getting, over 3,000 live viewers doing this speed dating of the Discord simps. I mean, oh my God. Just don't. Look, guys, she wouldn't talk to you in real life. She just wouldn't. You would be, she would only talk to you if you gave her food and she told you that her salad was overcooked or something. That's it. Don't pay attention to these thoughts. They're vapid. They're horrific, people. Don't do it. I'm not watching them. KRS. It's not me watching them. I got the news story about it. So anyway, but yeah, my thought news feed has had no Belle Delphine in it for over a year. I guess when she went full porn, she got unpersoned by Thought News, maybe? Maybe that's what it was? I don't know. I'm gonna come. It's Jack. Jack says, overcook the salad. You make my inner chef sad. No, that was the joke. She would tell you that you overcooked the salad, right? Like, because she's... Anyway, never mind. Never mind. Comedy's hard these days, especially when you're not a comedian. Renee Villarreal says, any alcohol recommendations? Also, do you like tequila? I have lots of alcohol recommendations. I am not the biggest fan of tequila, personally. Whiskey. I just like whiskeys. Different kinds of whiskeys. But I'll do this. Angel's Envy finished rye. Finished in Caribbean rum casks. It's the Angel's Envy bottle, but it's got green writing on it. Angel's Envy finished rye. You cannot be sad about that bottle. It is a phenomenal rye whiskey. And there you go. General Isimo says, Ricada Law, mine can keep growing and improving. I hear as soon as I join the stream. Hey God, it's me, Nick's penis. Are you listening? In all seriousness, Kyle's judge is cruelly giving me hope. Yes, that is the other thing to talk about today. Some interesting stuff with Kyle Rittenhouse, not in his case, but in related to his case, which I'll get to in just a second. And then we're doing the EVS thing. Marty Lund says, if a person acting as his LLC or corp causes injury and I sue them into oblivion, how likely am I to collect assets in the liquidation versus, say, other creditors? Can you or family be creditors and claim assets to defeat judgment? Typically, a judgment would go before. I think it would take first lien position over other creditors. I believe. It's been a while since I did secure transactions, but I think judgments get first lien position. However, judgments are also removable by bankruptcies, whereas secured lien positions are not. So it's all going to depend. It's all going to depend. Marty Lund. Oh wait, yeah, I just read that. Marty, what's going on, Marty? I hope that's a hypothetical. Andrew Bin says, I went to training with a guy who would cover his salads in ketchup and then microwave them. What is, ew. No. Come on, man. That's disgusting. Yuck. And Fan Advocacy Network, this is a little early, but I'm gonna read it anyway because it's correct. He says, I'd rather speed date a bullet than a Twitch thought. There you go. Okay, briefly. Stop that. Fuck you. Briefly, we've got, I think I might have missed very, very early super chat. Let me grab that while I'm doing this too. Kyle Rittenhouse. By the way, I finally put a thumbnail up on the Kyle Rittenhouse stream. Lots of people have been watching it, and it's a good one. In my opinion, it was a good one, even though it's 5.5 hours. I thought it was a very good stream, and people keep coming to it, so I put up a thumbnail on it, and I think the thumbnail is really terrific. Look, I'm just gonna put it out there. I think you should check it out. That's all, because I did some good work on it. Richard Grubber says, a friend showed me a good anime, 91 Days. It takes place in Prohibition-era Midwest USA, where a boy gets revenge on mobsters who killed his family. Oh, that sounds cool. That sounds great. Never heard of it, but it's that's really interesting. Maybe that's a troll. I don't know. Okay, Kyle Rittenhouse. So this is something really interesting to me in Kyle Rittenhouse. If you guys don't know, Kyle Rittenhouse had different attorneys before, right? Right now, Kyle Rittenhouse has Mark Richards, some other guy, Robert Barnes, and Free Kyle USA is the Kyle Rittenhouse Defense Fund that exists. Well, they have some interesting stuff going on. I'll show you their pinned tweet here. Hi to everyone who started following Kyle's defense page. So Free Kyle USA is now the Kyle Rittenhouse Defense Fund. There you go. He says, we have reached 90% of our goal of $100,000. This bucket of donations was processed today to pay for an amazing jury consultant team, research, and trial prep from the best in the business. This is something I was mentioning on Kyle's case because we talked a little bit about jury selection and what you have to do in a case like this. You have to have experts. And we're talking body language experts. We're talking social media gurus. We're talking people who can vet the jury independent of their voir dire answers. Because in voir dire, you get to ask the jury a bunch of questions, and the jury has to answer under oath. But this weird thing happens when people are under oath. Sometimes they lie. Like we know that in Chauvin's case, one of the jurors, frankly, just lied about his attendance of a Black Lives Matter rally earlier in the year. He just lied about it, and there was not a sufficient social media research team for Derek Chauvin to pick up on that guy's stuff. And it's almost an impossible task. I mean, there's the lengths you have to go to find these people. That's why I say you need a really expert social media research team. Hiring that is very, very expensive, and this is something that Robert Barnes has talked about a lot. In fact, that tweet sounds similar to something Barnes would say, and he has talked about the jury consulting and how important it is in these major media cases. So that's the good news. That's the good news. This is the interesting thing here, though. This is the interesting thing. Prior to having his current attorney team, he had Lynn Wood managing the social, the fundraising, all of that stuff. And he had a guy named John Pierce representing Kyle. John Pierce most recently was in the news because he's representing some January 6th defendants. And he allegedly got COVID and was hospitalized and on a ventilator and stuff like that. And he passed off the cases to someone who wasn't really licensed to practice law in those jurisdictions. This is really weird, kind of messed up thing. I don't know. Robert Barnes does not have anything nice to say about Pierce. But here's the deal. They fundraised $2 million for Kyle Rittenhouse to post bail. Now, if you post a cash bail and you don't bond it out, but if you post a cash bail, then when that bail is satisfied, if you are not guilty, you make all your hearings and all of that stuff, it comes back to the person. It comes back to the party. Here we go. This is the law firm of Xavier Solis, LLC. He is a lawyer on behalf of the Fight Back Foundation. That is Lynn Wood's organization. All right. On behalf of the Fight Back Foundation, this letter serves to inform the court that the $2 million cash bond posted in Kenosha County case number 20CF983 on behalf of the defendant Kyle Rittenhouse was made using funds of the Fight Back Foundation, which was received from its supporters. The Fight Back Foundation supporters, not Kyle Rittenhouse, they're saying. These funds were transferred by the Fight Back Foundation to the Pierce Bainbridge Law Firm's trust account and paid by attorney John Pierce on behalf of and as agent for the Fight Back Foundation. Attorney John Pierce is no longer the agent for the Fight Back Foundation. Accordingly, the $2 million shall be returned to the Fight Back Foundation if and when such funds are released, consistent with Wisconsin law and pursuant to court rulings, releasing the bail money back to the individual or entity that posted the cash bail. So, Linwood's Fight Back Foundation is trying to take the $2 million that was donated on behalf of Kyle Rittenhouse back to the Fight Back Foundation, which is an interesting question. Who should get it? This was just sent on September 17th. So who should get this? Should Kyle and his defense team get it? I think yes. Because I think that money was donated for Kyle's legal defense and that's where that money should go. Should Linwood and the Fight Back Foundation get it? I don't think so, but there is an argument that Fight Back would be the one. So I just wanted to let people know that that's what's going on in Kyle Rittenhouse's case. And it's a doozy. It's a doozy. All right, let's get on to this thing. I think we're about ready to go here. Okay. Now you probably don't remember the initial complaint. We did go through it, but the long and short of the initial complaint was that DA Talks, aka Dean Asaf, and Ethan Van Skyver and Vickyverse all got together and said some very mean and defamatory things against or about Pegston Poulter and a guy named John Lamont. Ralph says, does it legally matter why it was donated? I think it only matters to whom it was donated. It depends. It depends. Charitable contributions, if they're charitable, and are earmarked for a specific purpose, have to be used for that purpose. I don't know if Fight Back is a charitable foundation. If they're 501c3, I'm not sure. But if they are, they have to be used for the purpose donated. But we'll see. We'll see. So they said some mean things. To give you some background on who all these people are. Ethan Van Skyver is EVS. He has a YouTube channel called Comics Artist Pro Secrets. He is probably the most prominent independent comic creator in the Comicsgate group right now, and he has been using Comicsgate Live as the title of his show on YouTube for quite some time. He is the guy who set up Richard C. Myers' GoFundMe and was part of my research into setting up Vic's GoFundMe, was how Ethan Van Skyver set up Richard Myers' GoFundMe. So that is who he is. He has been on the show several times. He is called the Human Sunbeam. He is also called the Master of Pies. That he is, you guys should check him out if you like comics. He was also a DC and Marvel comic artist for a very long time. DC primarily, and drew, wait, was he Marvel? I know he was DC for a while. I don't know if he worked on Marvel properties. I feel like he did a long time ago. But he worked on DC, and Green Lantern was one of the big ones that he worked on. But he's worked on pretty much every major DC property in some way or another. And he is a very, very controversial character. In fact, I do see someone in the chat saying he is a huge piece of shit. So some people do not like Ethan. He is a bit of a lightning rod. So that being said, DA Talks is a Dean Asaf, this is the first document we're going through. He is a YouTuber as well who has been caught up in the comics gossip sphere, as is Vickyverse, Victoria Kundert. I don't know DA Talks or Victoria very well. I've spoken to DA a little bit. I might have spoken to Vickyverse very, very briefly at some point, but not particularly. And on the other side of this are two people, John Lamont, who is an independent comic artist of some sort. I mean, I don't know if he's independent because he seems dependent on Preston, but maybe, he's not part of a major comic book publishing arm. And then Pegston Poulter, who is a very, very weird independent comics artist who is called Peggy for a very specific reason. Peggy is the nickname of Preston because Preston came out as anti-Comicsgate, right? And in the heat of that back and forth where he chose to be the heel of Comicsgate for whatever reason, when he did that, someone went out and looked up his history and found out that he had done pornographic videos with his ex-wife, at the time his wife, in which he would assume the birthing position and she would proceed to puncture his anus with a large implement. Okay? I don't know how the more polite way to say that. This is a thing that happened. Those videos were placed on the internet for consumption, presumably for revenue, on sites like Pornhub and various BDSM fetishist sites. That's how they were found. They were not hacked. They were not stolen. They were not privately made public against their wishes. This was all stuff that they wanted out there and then was out there. And then when people found it, it made him very, very, very upset. So that is the background on who Preston is. But Preston has also filed for a trademark of the Comicsgate name. He thinks he is entitled to it. It is a piss-poor attempt at a trademark theft, in my opinion, because whatever you think about Ethan Van Skyver, literally, and again, this show, whatever you think about people is fine. That's your baggage to carry. I'm not here to make you like or dislike anybody. I'm really not. Whatever you think about Ethan, he is, in my opinion, the undisputed owner of the Comicsgate mark because of his Comicsgate live show, which is a show that has a commercial benefit for him. He monetized it through super chats and ad revenue. He was the first person to monetize the Comicsgate name in that way that I know of. I haven't seen anybody else who can claim to have used it prior to Ethan Van Skyver. Maybe someone's out there, but I haven't seen it. Okay. And so to me, he is the one who holds the rights to the name. And this was actually attempted. Preston is not even original in this. It was attempted by Vox Day very briefly, in which Vox Day talked about taking the Comicsgate name for himself. That ended up not happening. It did not occur. Vox Day talked about it. But in my opinion, Vox Day would even have a better claim on Comicsgate than Preston would. So that being said, wait, Sheila Aliens, were you the one who found the pegging video? You said, I was just looking at pegging porn and found it. I have many questions for you. I have many questions for you, Sheila. Okay, well, congratulations. It was Sheila Aliens who found the pegging video by pure happenstance, apparently, which I'm maybe more uncomfortable with that. I'm maybe more uncomfortable that you were like going down the rabbit hole of Stumble Upon or whatever, and then you're like, oh, that's Preston. Oh, whoa. Like that is, whoo. And I see Ethan is in the chat, and he did say because he legally defended the trademark against Vox Day, which is true. As far as I know, it's true. I don't believe there was a lawsuit over it, but shockingly, legal defenses don't always require a lawsuit. So that being said, those are the parties involved. So if anybody is not aware of these people, you are now. Now, the lawsuit itself is over mean things that were said. And let me briefly recap that for anybody who might be new to these things. John T. Lamont drew a comic book. It's something. It's something. And according to the description that was put up on Kickstarter by John T. Lamont, the main character of the comic book is a female who is 17 years old. Okay? This is an important part of this discussion. It is a 17-year-old minor female. Now, this is art. Okay? So, I mean, as much as it can be. This is an artistic work. This is not, these are not photos of people. And in this comic book, the 17-year-old female is involved in a sexual relationship with a demonic entity, a succubus, if you will, I guess would be the popular sort of commonly identifiable description of what it is, but basically a succubus, a female sex demon, who looks kind of young, but definitely is like 5,000 to 6,000 years old or whatever. And her name is Lolita. So you've got, it's not a male. This is a female demon. So you have an underage character who's 17, right? And you have a young looking sex demon named Lolita. That's what you need to know about that comic book. And on a live stream talking about it, DA Talks, Vickyverse, and Ethan Van Skyver in some ways suggested that that the art might be a bit creepy, maybe even pedophilic. I mean, just maybe. And I believe Ethan said something along the lines of, I'm going to have to defend the trademark because this is being marketed as a Comicsgate comic or something like that, or they talked about it. And he said, I don't want Preston to publish a book under a pedophile comic book under Comicsgate. Some other people said, kind of looks like a pedo, like this gives me pedo vibes or whatever. So there's some accusations about how the comic book felt. And so this lawsuit is a defamation claim saying that these people said that these John Lamont and Pegston Poulter were pedophiles, which I must be very clear. I don't think in any way they ever said that either of these people were definitively pedophiles. But the impression that they got from the art was that this was pedophilic and inappropriate. So I echo the sentiment, fully echo the sentiment. It's a weird comic book. I've looked at the art and I'm looking at the wall. I'm looking at the wall. That being said. Oh, yeah. Quartering. He is actually suing. All right. Richard Pierce says, quote, I was just looking at porn. Oh, if only I had a nickel for every discovery I've made under those circumstances. Okay. So there's the lawsuit. So they have sued. Now, this was filed a little while ago. August 4th of 2021. Dean actually answered the lawsuit. Dean is DA Talks. This actually might have been a bad move for Dean to answer this lawsuit. Ethan did not answer the lawsuit. Instead, he filed a motion to dismiss under Rule 12b-6 and under a lack of jurisdiction. Dean would later file a motion to dismiss, but because he filed this answer, it may eliminate one of his potential motions. And I feel like I said it at the time, but maybe I didn't. Here we go. That is the backstory, what's going on. So we're going to take a look at Dean's answer. And it looks like Dean took this, basically, he's representing himself. Oh, excuse me. And it looks like Dean kind of took a template answer, but maybe from California or something, because this is, it's got some defenses that are under California law as opposed to Texas law. This lawsuit is filed in federal court in the state of Texas. Comes now. The defendant, Ali Asaf, that's Dean, in answering the allegations of plaintiff's complaint, admits and denies and alleges the following. This is how answers are written. You go through paragraph by paragraph from the complaint, and you either say, yes, this is, you admit this is true, or you deny that this is true, or you admit in part and then explain the denial. That's it. You can deny an allegation without any explanation. But if you admit in part, you need to tell the court what part you admit to. Okay? Defendant admits that his true name is Ali Asaf, also known as Dean Asaf, and that he is a citizen and resident of California. Defendant admits that I go by DA Talks on YouTube. Defendant lacks sufficient information to determine the truth of the statement set forth in paragraph 7 of the plaintiff's complaint. I don't know why you're on paragraph 7 for paragraph 3. To the extent that defendant does possess sufficient information, defendant denies that statement. And we're going to see a lot of these lacking sufficient information. I'm going to skip those because they get really boring. So he's got a bunch of denials, which is the appropriate thing to do in most civil cases, right? You're going to deny the allegations because most of them aren't going to be true. Stupid fly. You're not a wasp. You can't make me cry. So he didn't, here's what we need to get to. He doesn't have sufficient information about this stuff, but he denies that this court has subject matter jurisdiction over this lawsuit as mentioned in paragraph 8 of the plaintiff's complaint. I mean, the court probably does have subject matter jurisdiction. It's a federal district court. The question would be, is there diversity jurisdiction here? I think there is, but that being said, subject matter jurisdiction, he says that they don't. The court will probably rule that it does. Generalissimo says, underage sex demon. That's all you had to say. Sign me up. I definitely will buy, read, and enjoy this definitely not predatory material just as soon as I finish feeding myself into this wood chipper doused in flaming diesel. So here we go. Defendant denies the statements and allegations. To the extent he denies. Okay, so he denies all of these allegations, and it's great. Now he has affirmative defenses. What's lacking from this is something very important, and this is why you should always have a lawyer draft up an answer or help you in a federal case if possible, or in a state case. In a federal case, this court has no jurisdiction over DA Talks, okay? Let's be very clear. The court does not have jurisdiction over DA Talks. His court's in Texas. He lives in California. There's no indication at all that DA Talks did anything directed at Texas. He was making a YouTube video. He's talking about stuff. There's no way that is directed at Texas in any way. He's not contacting Preston. He's not on the phone with Preston or John Lamont or any of these people. He's not like pissing into Texas from Oklahoma while doing his broadcast. Nothing like that is happening. He has no ties to Texas that we know of. And more importantly, Peggy didn't allege any actual ties to Texas. But DA Talks answered and did not motion for a dismissal for lack of personal jurisdiction. And if you don't move the court for dismissal based on lack of personal jurisdiction or raise it as a defense, then you will forfeit your ability to claim no personal jurisdiction. You waive it. You say, if you don't assert it from the start, you actually waive it. And that is going to be one of the minor problems here. Now, overall, is that a huge issue? No. DA Talks has just fine defenses, but He really should have raised that issue to save him some headaches, because this should not be brought against him in in Texas when he's in California. And the court very likely will see this as a waiver. I mean, there's some possibility that the court, I guess, on its own motion will say they don't have jurisdiction. They tend to do that for subject matter jurisdiction, though, not personal jurisdiction. All right, so defense number 1, truth. Defendant denies the allegations set forth by plaintiffs in paragraphs 24 through 38 in that the allegedly defamatory statements are at least substantially true. So it's like, yeah, he is a pedo. What a creep. Statement of opinion. These allegations are, if they're not truthful, then they're just opinions, bro. They're not factual. It's just his opinion that he's a pedo. Consent to the publication of the allegedly defamatory statements. He's saying that the plaintiffs consented to the publication of any allegedly defamatory statement in question. I'm not sure how he would go ahead and argue this, that he would say, hey, Preston, I'm going to call you a pedo on stream. So this is probably a bad defense. The first two are fine. Number 3, qualified privilege, in that any alleged defamatory statement is afforded protection from liability due to considerations of public interest that outweigh the need for redress. There's a common interest privilege where communications are made in good faith dealing with matters of public concern without actual malice. This is, I mean, not really a qualified privilege. This is just a defense to defamation in general. Absolute privilege. No. You don't have absolute privilege on these statements. But again, it looks like he's got a template and he's just grabbing stuff from it. And it's fine to raise all these defenses, I guess, even if they're not really going to be helpful to him. Retraction of the alleged defamatory statements. He says the defamatory statement has been retracted. I don't know where DA Talks would have retracted any of these statements. So that's interesting. But retraction of statements is a defamation mitigation technique. It does not eliminate the harm done by the defamation. Like I can't say something defamatory about someone, cause them harm, and then retract it and be like, it's all good, bro. Like, I know you lost your job and you're in prison or whatever, you know, from my lie, but I retracted it, so it's fine. That's not how that works. And again, I don't think DA did anything wrong here. I'm just pointing out that I don't see where it's been retracted. If I'm wrong, I mean, there's a lot of lore here that I definitely have not kept up on because I don't watch all of these videos. I don't know if he's ever come out and retracted it. But if he did, cool. Now he's got anti-SLAPP statutes as a statutory defense. Federal court in Texas does not recognize state anti-SLAPP statutes. So this defense will not work either. There is not an anti-SLAPP in the Fifth Circuit currently. We learned that with Richard Meyer. It actually happened not from Richard Meyer's case, but during the Richard Meyer case. The courts of the Fifth Circuit came down and said, we don't actually recognize Texas's anti-SLAPP law here in here in federal court. Now in California, in the Ninth Circuit, they would actually recognize the California anti-SLAPP law in the Ninth Circuit, but they don't do it in the Fifth. So not going to be helpful for here. Defense number 7, they're saying that the plaintiff already had a poor reputation. That's a really, really hard thing to prove. And while raising it again is not a problem, I don't think he'll be able to prove it, even though Preston is a dumpster of a human, literally, where things get put into him like a dumpster. Even though that is the case, having a sufficiently bad reputation to be immune from defamation would tend to require you to be a really, really horrific person, right? We're talking like a Jeffrey Dahmer, a Nancy Pelosi, something like that. Okay. So now we have some more defenses for cyber libel. Absence of an element of libel, so that there's no made no defamatory or libelous statement or imputation with any actual malice, nor made any written publication or dissemination of any defamatory or libelous matter to any person. So didn't libel them, and also no malice. I don't know if Preston is going to no, the quartering, his name is Pegston Poulter. Peggy is just his nickname because he liked to get pegged. That's all. Pegston Poulter is the name. I don't know that Preston is a sufficient public figure. I mean, maybe they would say he's a limited purpose public figure in this. I don't know. But I don't know if he's sufficiently a public figure to require actual malice. And then, the written publication or disseminated any defamatory or libelous matter. I mean, if the statements in the live stream were libelous, then you did. But I don't think they were. So I guess I agree. Defense 2, truth. They're substantially true. Opinion, consent, qualified and absolute privilege. These are the same things. This is just for cyber libel, which I don't know why cyber libel is distinct in this, but that's what, was done. Affirmative defenses he has here, but there's nothing else. So they're done. Now he's got the closing section. Notwithstanding the defenses set forth above, also submits the following affirmative defenses. Plaintiff's complaint fails to state a claim for which relief can be obtained. This is a 12b6, which he files later, and we'll get to. That'll I think, be maybe more interesting than this. Court lacks subject matter jurisdiction over this action. And again, the court probably has subject matter jurisdiction. There is diversity of citizenship between the parties as far as I can tell, and the diversity is complete. I think they've alleged over $75,000 damages, even though that's ridiculous, because this comic book made a whopping $24 or something on its Kickstarter. And even the highest Preston comic, and this wasn't a Preston comic, made something like 10 grand. So pretty sure that's not going to, it should not be a $75,000 claim, but courts are pretty lenient on that. So I think they probably do have subject matter jurisdiction if they sufficiently pled the 75 grand. And the venue is improper for this action. That's true. That is true, but you didn't raise the personal jurisdiction thing, and by the rules, you should have waived it with this filing. So all around, the substance of the answer, denying everything, is fine, and that's what you would do. That's the correct thing. The mistake was in filing the answer in the first place prior to your motion to dismiss for lack of personal jurisdiction over you. And that is, the court may be lenient on you. I don't know if they will, but that may be give the court jurisdiction. But otherwise, the follow-up motion we'll take a look at. But this court, or this case, should be thrown out under the 12b6, failure to state a claim. So I'm not trying to harp on DA talks here, just trying to talk law and let people know what's going on. All right. Next. Here is Ethan Van Skyver's motion to dismiss and brief in support of it. And, a new document. Ooh. Hold on. Got live updates here. Oh, perfect. That's fantastic. Thank you for that, Ethan. They had a filing today. So if we get there, we'll pull it up. We'll get there. Or if we get there, we'll get it up. And you can assume the birthing position. Okay, so this is a motion to dismiss and brief in support. First thing I'll point out, Ethan has a lawyer, and this is very clean. This is a very clean document. Having a table of contents is always helpful. And just as a pro tip to everybody, if you're ever in especially federal court. Put a table of contents in your thing. Make sure the table of contents is accurate. Your judge will like you for it. More appropriately, the clerks will like you for it. So we've got an intro, factual background, legal standards, request for judicial notice. This will be fun. Personal jurisdiction arguments, plausible claims. So this is 12b6. Arguments and authorities. Internet contacts from a passive website are not sufficient for personal jurisdiction. Van Skyver has no contacts with Texas. This is what I was talking about with the personal jurisdiction, and I can pretty much tell you what this is going to say, and I agree with it already. Failure to state a claim under 12b6. This is filed in most civil actions, a 12b6 motion, because if you win on a 12b6 motion, you say they didn't sufficiently plead out their case, you win. You win forever. It is the total victory, and it's a total victory with prejudice, and the case is over, and they cannot sue you again. So 12b6 is a very common motion, one that you should know if you're, talking about this stuff. And then we've got cases, a table of authorities, different cases that are in this, and the pages in which these cases are referenced. This is a nice thing to put in as well. These may be required in federal court. I don't remember. It doesn't matter. Defendant Ethan Van Skyver respectfully moves the court to dismiss the lawsuit against him because the court lacks personal jurisdiction over him pursuant to Federal Rule of Civil Procedure 12b2, and because the First Amended complaint fails to state a claim upon which relief can be granted under 12b6. Now, the interesting thing is, if you prevail on personal jurisdiction, the court will typically actually dismiss it, but without prejudice, which would allow the other party to refile. So some people strategically accept the court's jurisdiction over them and then go for a 12b6. Other people do not. There's not a better or worse way. It's just preference. If you think they're going to refile and go after you, then maybe. I don't think that Preston wants to sue any of these people individually in their individual jurisdictions. And I think that's why he filed the case in the way that he did. If there was a party he would probably go after individually, it would be Ethan, but I don't know. I'm not, thank God, I'm not in Preston's head here. And personally, what I would do, I would definitely file for the dismissal for no personal jurisdiction. That's the move that you would want to make, because fighting in Texas is easier for Preston because that's where he is. If he had to sue Ethan Van Skyver in New Jersey, he would have to hire a New Jersey lawyer. He would have to potentially fly out to New Jersey. He would have to fly lawyers out to New Jersey to do depositions. This would be a big thing here. That's why people don't want to fight in different jurisdictions. So I think the personal jurisdiction defense is the proper defense to lead with, even if it doesn't always get you a dismissal with prejudice. A dismissal without prejudice can be sufficiently dissuading to the other party, and you want to take the win where you can get it. Plus, New Jersey would maybe even be a more favorable destination for this to be fought than Texas, because I don't know if New Jersey's circuit courts recognize anti-slaps, but they might. I don't know if New Jersey has one. Haven't looked into it. Introduction. As plaintiffs allege in the First Amended complaint, Van Skyver is a resident of New Jersey where he grew up. Hold on, I'm getting this over onto my main screen so I can read it a little easier. What's the difference between personal jurisdiction and subject matter jurisdiction? That's actually a really good question. So subject matter jurisdiction of the courts is determined by Congress. Federal courts determine what jurisdiction over issues, what subject matter the courts can hear, right? So federal courts can hear tort cases, but they can only hear tort cases that occur under state law in the case that they have something called diversity jurisdiction, right? Where all of the parties on the plaintiff side and all of the parties on the defendant side are completely diverse in citizenship to a state. So Ethan Van Skyver is a resident and citizen of New Jersey. D.A. Talks is a resident and citizen of California. Vickyverse is somewhere else. I don't remember, but not Texas. Pegston Poulter is in Texas. I think John Lamont is also in Texas. But so long as no one on the defense side and no one on the plaintiff side lives in the same state, you have total diversity. All right? So in federal cases, the reason this is because if you read Article 3 of the Constitution, it says that they are to resolve disputes between residents of one state and residents of another state. So that is their subject matter jurisdiction. That is how the diversity of citizenship is figured out. And the claim or controversy has to be in excess of $75,000. It started off as $20, but that was in 1790 or whatever. Lamont is in Florida. Okay, there you go. Thank you. So that is the subject matter that they have jurisdiction over. It's a state tort claim. You're under Texas defamation law. This isn't a federal defamation claim that doesn't really exist. So the only way the federal court would have jurisdiction over this subject matter of a state tort claim would be if there's sufficient diversity of citizenship. That is a separate question from personal jurisdiction, which says, does the court have the authority to bring someone under its jurisdiction, to demand that they appear? And the question is, if they don't show up, can the court issue a warrant for a sheriff to go get them? Now, we'll take Ethan versus Preston. Texas is where the case is brought. Ethan is in New Jersey, right? If Ethan has never been to Texas, doesn't do business in Texas specifically, doesn't advertise to Texans, isn't doing business with the Texas government, then he's not in Texas. So how could a Texas court decide to grab Ethan Van Skyver and bring him into the state to court, like demand that he show up at a hearing? If he doesn't, issue a warrant to make him show up or issue fees against him. Ethan's like, you don't know me, bitch. You got nothing on me. I'm not from Texas. You can't haul me in there. And so that is personal jurisdiction. And personal jurisdiction they have to have over every single defendant, and they have to have it independently. There's no I've got jurisdiction over this person, therefore I grab this other person. Nope. You have to be able to be brought before the state. And you can do that by purposeful availment, where you say, by submission to jurisdiction, I submit to the jurisdiction of this court, or by purposeful availment. And that's where you do something where you enjoy protections from Texas sufficient to bring you under their jurisdiction, like driving through Texas, right? You can't say, well, I'm not from Texas. I was just driving through it. Well, if you commit some sort of tortious acts inside the state, then you were there, and presumably the laws would protect you while you were there. Therefore, they protect the other people while you're there as well. Or if you have sufficient repeated business contacts where you're doing business, and then that's the same thing. The laws are there to enforce the contracts that you're engaged in, the business conduct that you're doing. If Ethan is going to a bunch of Texas conventions, for example, if he's popping up in San Antonio and then in Austin, then in Dallas, then in Houston, he's doing speaking engagements, he's making a couple $1,000s for each one of these things, and he's signing autographs and all that stuff. Well, then he's taking advantage of Texas's legal protections, his contracts, and those, oh, you fucking fly. And those, those business engagements that he's in. Texas would be protecting him. Therefore, he is making sufficient contact. Ah, you motherfucker. Ah. I hate flies. Therefore, Texas is protecting him. Therefore, if he fucks around, he'll find out, because Texas can come calling. Say, hey, we protected you here. Now you're under our jurisdiction. So that's the short layman's term sort of analysis of this. And this all comes from some old case law, like International Shoe, which we'll probably see. And Calder v. Jones is another one. There's some other ones. I don't remember all of them off the top of my head. I don't practice in federal court, but this is one of the first classes that you have to take in law school everywhere. It is civil procedure, and every law school teaches federal civil procedure. So that's where you learn all of this stuff. It's going to be some of your first classes that you take, and you will be bored to tears. Yes. Okay, so he is a resident of New Jersey where he grew up. He has worked in the comic book industry for decades, including at DC Comics and more recently as an industry commentator at all times while residing in New Jersey. As an industry commentator, Van Skyver has developed and used a trademark, Comicsgate. Recently, plaintiff Pegston Poulter has used and claimed a right to this trademark. Richard Pierce says, at Comic Artist Pro Secrets, I read Blood Honey, and since then have been suffering from erectile dysfunction. You'll be hearing from my attorney. His name is Kurhis, and he's kind of a drunk. Be nice, you CG jur you. I don't know what that means. Plaintiffs are independent comic book creators who have filed this suit against Van Skyver in connection with 2 comments Van Skyver made during one online broadcast where he said he did not want his trademark placed on material that he deemed graphic and inappropriate. The comments were made during an online show broadcast on YouTube during which Van Skyver's Comicsgate mark and plaintiff's work called The Demonatrix were discussed. Van Skyver was a guest participant on that single YouTube broadcast, a 1-hour, 8-minute live stream broadcast to approximately 750 viewers on April 25th, 2021. Notably, here's where you can go see Preston get called a pet. No. Notably, during the live stream discussion, defendants displayed plaintiff's own drawing, which enabled viewers to form their own opinions about whether the material was graphic. Plaintiffs allege only 2 statements made by Mr. Van Skyver were defamatory. He says, number 1, I don't want Preston to make child pornography and put Comicsgate on it. That is not a defamatory statement. I don't know why anybody... there's not even a path to that being defamatory. Like, there are many worse things that could be said that would still not be defamatory. But, yeah. I could... Here. I don't want Preston to make child pornography and put Ricada Law on it. There you go. That's not defamatory. Because that is a true thing that I don't want to happen. And number 2, in order to have a trademark, you have to protect it. I will not allow it to be put on child pornography by Pegston Poulter. So there you go. Again, facts. Those are the 2 statements at issue. Easy with the hot takes. Based on these 2 statements, plaintiffs allege a host of damages. Mr. Poulter alleges on Kickstarter, former customers refused to support him signing his association with a pedophile. I don't believe this at all. And that Mr. Poulter will continue to suffer pain and mental anguish since the remarks have been disseminated into a large part of the community of comic book professionals and enthusiasts. Yet, as shown below, the Kickstarter campaign was canceled before the allegedly defamatory statements were made. Bum, bum, bum. That is a problem for Peggy. Mr. Lamont makes similar damages allegations, adding Kickstarter declined to approve his next book project and has shut him out with unprecedented demands. Bro, your Kickstarter did like $20. It was terrible. Critically, plaintiffs have not alleged any facts that establish that this court has personal jurisdiction over Van Skyver, and dismissal of the claims against him is therefore warranted. Further, the claims plaintiffs have alleged against Van Skyver do not state a claim upon which relief can be granted because the alleged damages were incurred prior to the alleged defamation. And plaintiffs failed to plead all elements of their claims. Footnote, as independent comic book creators, plaintiffs must obtain their own funding and had apparently sought funding for the Demonatrix, it should be, by crowdfunding on the platform, Kickstarter. And if you look up Kickstarter for the Demonatrix, you can actually find this thing. If you just look up the Demonatrix, you will not find it because the Demonatrix is like a group from a CW show. And if you know anything about CW, you know that the CW actually stands for Cancer Worldwide. And since the Demonatrix comes from a Cancer Worldwide Network show, it is full of like fan wikis and shit from people who like cancer worldwide. And so you just a marketing pro tip. Do not name your crowdfunded comic after something that is stupidly internet popular, like a CW show. If you have like a baller idea for a title, go in, type it up into Google, and see what comes up. And if what comes up is the Demanatrix, I mean, shit, here. Okay, we're doing it live. It's from Charmed. It's from Charmed. Demanatrix. Here we go. Charmed Wiki. See? This is the Demanatrix. A bunch of Buffy clones. That's what they are. Right? Guess what? John Lamont is not going to compete with a bunch of sexy blondes in leather. It's not going to happen. Because this is not pedophilic. But John Lamont's stuff might be. Might be. So, here you go. You're not going to outdo this with your weird book. Here No, that's not even it. This is something else. Whoa! They're covered. But see, someone else came up with this idea already. A rocky, sexy, nightmarish romp. A VHS. Matrix. Just Google the thing that you want to call your own comic book, your crowdfunder, and realize that when people search for your thing, they're not going to find it. It's not a good system. So there you go. This is the big problem. Don't call your thing the Demanatrix if they exist in a show that's as big as Charmed. I can't keep scrolling down. You'll have to scroll down on your own. I've already shown too much. Accordingly, Van Skyver requests the court dismiss this suit against him because 1, court lacks personal jurisdiction, and 2, plaintiffs have failed to state a claim upon which relief can be granted. Factual background. Oh, also, you'll note very importantly that there are no documents from Wikiverse, and that is because Preston failed to serve Wikiverse. Just failed to serve. And may not get to. May have forfeited his ability to serve Wikiverse by just not pursuing it in a timely manner. And you know what? Good. Good. And not because I have some affinity for Wikiverse. Again, never really talked to her. However, what I will say about this is very simple. Preston has done this before. Preston attempts to utilize, from what I understand to be, some sort of trust fund or inherited money. I don't know. This is what I understand. Some sort of inherited independent wealth to bully other people using the legal system. As a lawyer, that is extremely offensive to me. As someone who has represented people through real claims that have real impacts on their lives, the amount of money, time, and stress that puts someone under should only be undertaken under serious circumstances. And if that's what you're doing, then you are shit and scum and deserve all the bad things that people can imagine. I hate it. I hate people who abuse the legal system in that way. That's not what it's for. If people have ever asked me to bring suit against someone and I don't think the claim is good, that's what I tell them. And if they don't like that, they can hire a different attorney. I don't care. That's not my thing. I will not abuse people through the legal system ever. I think it's disgusting because you can't avoid it. Like you have to respond, and that response costs time, money, and stress. And so the people like Preston really suck. Okay, so the alleged defamation stems from a comic book discussion on the YouTube channel entitled Vickyverse, hosted by defendant Victoria Kundert. You stop flying at me. Go anywhere else in this room. Jesus. Hosted by defendant Victoria Kundert and co-hosted by defendant Dean Asif on April 25th, 2021. Like many YouTube channels, it preserved this broadcast in the public record word for word, which allows the reproduction of the alleged defamatory statements in context as they occurred. And then we've got the link again here with a timestamp. The context shows that defendants accurately portrayed plaintiffs as comic book creators and even displayed the image from plaintiff's Kickstarter campaign for the comic in question, The Defamatory. Do you guys want to see that? Do you want to see the comic? Should I pull it up to remind you of the top level comic book creation that it was? I mean, this is the top shelf comic creation we have going on here. This is the tippity top. This is the Lolita demon. 4 backers, $26. Boom. Boom. Now, notice this was on March 16th of 2021. It was canceled by the project creator, and importantly, this discussion was on April 25th. So we have real stuff going on here. Emerald May Riley was a typical 17-year-old growing up with her overbearing evangelical father. Blah 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 blah. She summoned the violent and sex-crazed demon Lolita, who took over her body, murdered her father, and sent her friend to the hospital, with the police and the heavenly hosts quick to track her down. Lolita leaves Emerald's body behind to take the rap and embark on a drug and sex-crazed trip throughout a modern metropolis. And here you go. You've got some of this weird shit 3D art that is just awkward. I don't like it. That's the lovely variant cover. I can't show the rest, I don't think. Hold on. Let me see how far we can go. Oh, it's censor blocked. Oh, Jesus Christ. Here's the one you really probably kind of need to see. You need to see this one. Very, very uncool, in my opinion, to have this. But, you know, that's what they did. Shockingly, this magnificent artistry did not do more than $26. But there you go. Okay. The context shows that defendants accurately portrayed plaintiffs as comic book creators and even displayed the image from the plaintiff's Kickstarter campaign for the comic in question, The Defamatory. Viewers of the live stream saw for themselves exactly what plaintiffs were producing, a cartoon drawing, and would have easily recognized that the use of phrases child pornography and pedophiles were merely hyperbolic descriptions of the cartoon drawing. The discussion involving plaintiffs began with a discussion about defendant Van Skyver's efforts to trademark the word Comicsgate and to discredit Pegston Poulter's claims to the mark. During this discussion, the host played pre-recordings of both Mr. Poulter and Mr. Van Skyver discussing the trademark issue. The image below of the plaintiff's comics, The Defamatory, oh, it was right here! The subject of this defamation lawsuit appeared during the discussion. And so then here's the certified Comicsgate trademark with the shit logo of the fake Renfamous or whatever that he's got going. From 1622 to 1615, the image above from plaintiff's Kickstarter campaign appears at 1644. Nudity redaction in the original. Logo detail at the right is added for clarity. Mr. Van Skyver pre-recorded. This is from his comments that they were playing from a clip. So Comicsgate is trademarked and feel free as long as you abide by the principles and rules, the standards that we all kind of understand Comicsgate is. There's not going to be a problem. If you want to publish child pornography under the Comicsgate banner, that's going to be a problem, or anything like that. And in that instance, I will come down and exercise my trademark and protect the mark. From 3010 to 3038, Mr. Van Skyver joins the live stream in person. DA says, want to hear your side of things. Van Skyver says, well, I mean, you know my side of things. Fortunately, I talk about almost everything pretty openly on my channel. But I mean, my side of things is that it's pretty demonstrable that Comicsgate has been used in commerce by me and me alone up until Preston decided he would try to spite trademark the term. I just don't think anybody is going to get very upset and think that I'm, co-opting a movement. All of those accusations have already been made and put in. Are you? Okay, we're back. Are you fucking kidding me? With this internet. My goodness. Ugh. Go ahead and refresh if it desynced your audio. Jesus. All right. Starlink isn't available in Minnesota yet. So I can't do Starlink. But that wouldn't have... Never mind. I'm not going to sit here and argue with the chat about this. In order to have a trademark, you do have to protect it, so I will protect it in that way. I will not allow it to be put on child pornography by Pegston Poulter. As demonstrated above, Mr. Van Skyver was discussing his efforts to protect his trademark Comicsgate against an improper use by plaintiffs. The improper use is prominently displayed during the discussion. Legal standards. Request for judicial notice. So judicial notice is where you tell the court, hey, you have this thing in front of you. This is before the court. We want you to recognize what's going on officially. We want you to take notice on the record of this thing. To the extent the court references the above live stream excerpts and the attachments to this notion when deciding the motion, Van Skyver respectfully requests this court take judicial notice of those materials because those are specifically referenced and incorporated into plaintiff's first amended complaint. In particular, plaintiffs referred to the live stream as the source of defamation and statements in the live stream. The other documents also expand on the items directly referred to in the complaint. The plaintiffs' The Demonatrix campaign on Kickstarter and Kickstarter as a party before whom plaintiff's reputation has been damaged. Thus, the campaign and the basic facts about Kickstarter, its location, are also incorporated by reference into the complaint and not matters outside of the pleadings. So they're saying they complained about this campaign. This campaign is part of the case. And really, when you're dealing with underage art, we'll say, you want that in front of the judge as much as possible. You want the judge to look at that and go, these people are disgusting. Under such circumstances, the court can properly take judicial notice. The live stream and the 3 exhibits are obtained from public records and are not subject to reasonable dispute. Their content can be accurately and readily determined from sources whose accuracy cannot be reasonably be questioned. So they don't want Preston trying to exclude parts of the live stream as unfounded or something like that. Try and weasel his way through this process by having the judge exclude various pieces of the evidence. They're saying, nope, this is all there. Ryan H says the chickens are pecking your internet. No kidding. No kidding. Personal jurisdiction exists when a defendant purposefully avails himself of the privilege and benefits of the forum. We talked about this earlier. As the United States, this is a good one. The Ford Motor Company versus Montana. This case just happened earlier this year and was a really pretty interesting case. As the United States Supreme Court recently stated, quote, a tribunal's authority depends on the defendants having such contacts with the forum state that the maintenance of the suit is reasonable in the context of our federal system of government and does not offend traditional notions of fair play and substantial justice. In this case, Ford Motor Company had a car. That car had a defect that led to an accident in Montana, and Ford Motor Company tried to claim that they could not be brought into Montana under Montana's jurisdiction because the car itself that was defective was not made in Montana, nor was it made from any parts in Montana, nor was it sold in Montana. However, Ford sells a whole fucking lot of cars in Montana. Therefore, Ford could be brought in to Montana. So there you go. In order to establish personal jurisdiction, in a diversity case over an out-of-state defendant, the plaintiff must present prima facie evidence that 1, the long-arm statute of the forum creates personal jurisdiction over the defendant, and 2, the exercise of personal jurisdiction is consistent with the due process guarantees of the Constitution. Because Texas's long-arm statute reaches to the constitutional limits, it is only necessary to assess if the court's exercise of personal jurisdiction offends due process, citing Helicópteros Nacionales de Colombia. Due process is satisfied when the defendant has purposefully availed himself of the benefits and protections of the forum state by establishing minimum contacts with the forum state, and the exercise of jurisdiction over that defendant does not offend traditional notions of fair play and substantial justice. This should just be written down as a civil procedure paper, because that's what this is. Minimum contacts are found supporting specific personal jurisdiction when the defendant's contacts with the forum arise from or are directly related to the cause of action. That's Revel versus Lidov. So the contacts have to be related in some way to the cause of action. You can't, let's say Ethan went to a convention 10 years ago in Texas. That'd be unrelated to this cause of action unless he talked about Preston back then. And that's this important part. One state's sovereign power to try a suit may prevent sister states from exercising their like authority. Law of specific jurisdiction seeks to ensure that states with little legitimate interest in a suit do not encroach on states more affected by the controversy. And that's Ford Motor Company. Because, again, you only get one shot. And so if Texas isn't the right state, but New Jersey is, but Texas takes the jurisdiction, and it should have been New Jersey, then they've just robbed a state of their sovereignty over something. Plaintiff must plead plausible claims to avoid a Rule 12b6 dismissal. So this is, the writing style here is something called IRAC. It's IRAC. It's introduction, rule, analysis, conclusion. That's it. So we're in the rule phase here. They've laid out the rules for this personal jurisdiction. They've laid out the rules for 12b6 dismissal, and then we're going to get into the analysis. And this is how most legal writing is done. It's, you know how they always told you in high school, you write intro paragraph, 3 body paragraphs, and a conclusion or whatever. Intro section, 3 bodies. This is the law's version of that, and standardizing it really helps organize a motion. Did it hiccup again? God damn it. Following this format, 1, it helps you organize your arguments. 2, it's the way that everybody is organizing their arguments, and that makes it easy for the readers who have to read through tons and tons and tons of these things. If you don't follow this format, the clerks and the judge will hate you because it makes your document difficult to read. A plaintiff must plead plausible claims. To survive a Rule 12b6 motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. And this is the Iqbal Twombly line of cases. Ashcroft versus Iqbal, Twombly versus Bell South, I think it is. And this states that you have to plead actual facts. You can't just plead bare allegations or conclusory statements. A facially plausible claim pleads factual content that allows the court to draw the reasonable inference that the defendant is liable. And threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Conclusory allegations and unwarranted deductions of fact will not suffice to prevent dismissal. So you can't just say, Ethan Van Skyver defamed me, right? That's a conclusory statement. That is a legal conclusion. You have to show how Ethan Van Skyver defamed you. Ethan Van Skyver said, I didn't like apple pie, and that makes him a liar and a coward. So that's how you have to do it. You can't just say that he defamed you or he published a statement. Okay, where did he publish it? How? When? To whom? How did these things happen? You have to have the facts. Even if your facts are wrong, you have to have them in there. Internet contacts from a passive website are not sufficient to establish personal jurisdiction. So now we're in the argument section. Plaintiff's First Amendment complaint does not allege that Van Skyver has any contacts with this forum. The only contact defendants have with this forum is via the internet, which is a tenuous contact at most. The Fifth Circuit applies a sliding scale test described in Zippo Manufacturing to decide whether a defendant has sufficient minimum contacts with the forum state via the internet. The test requires an examination of the extent of the interactivity and nature of the forum contacts and categorized internet use into a spectrum. And everybody on the internet is on the spectrum. That's what they just said. At one end is a passive website that merely allows the owner to post information. This contact will not be sufficient to establish personal jurisdiction. On the other hand, personal jurisdiction will be proper in cases on the other end of the spectrum where the site owners engage in repeated online contacts with forum residents over the internet. The middle cases require an examination of the extent of the interactivity and nature of the forum contacts. YouTube is definitely a passive thing, right? First of all, YouTube is not in Texas. YouTube is a passive site. Anybody can upload to YouTube from anywhere in the world. No matter when. If you have an internet connection and you're not in China, you can upload to YouTube without any issue. And that's really as simple as it gets. YouTube doesn't care what site you are uploading from, what state, what jurisdiction. They just take it. And then they broadcast it out. And there's no real easy way to target where that broadcast will go. I mean, YouTube's algorithm sends it to different people and stuff like that. And if you do a show maybe about Texas, it might, route it to Texas viewers or viewers who are interested in Texas. And maybe then you could start to get into some weird stuff. Like there is a way to tag your location. And if you tag your location in Texas, for example, while talking about Texas, even if you weren't there, that might be enough. But that's not what's going on here. YouTube is passive. You upload it from anywhere and it broadcasts it to everywhere. Anybody anywhere can basically access the overwhelming majority of content. Van Skyver has no contacts with Texas. As the First Amendment complaint states, neither Mr. Van Skyver nor any other defendant lives in Texas or has had any significant contacts with Texas. The alleged defamatory video is not directed to Texas. The participants did not interact with anyone from Texas. They talked among themselves. Viewing this discussion required the unilateral activity carried out by about 750 listeners of those who tuned in by specifically seeking out the content on this particular YouTube channel. This unilateral activity does not qualify as purposeful availment. Contacts necessary to justify personal jurisdiction. So the users, the viewers, took the unilateral activity. They didn't require permission. Van Skyver did not set up a system where only Texas viewers could watch the show. I mean, in theory, I guess you could do that on some sites where you give out, like you send out private access to a live stream to specific people. This is just, the link is there. Whoever wants to click on it can. Further, the alleged damage is not centered in Texas. In defamation cases, however scandalous a publication might be, it can lead to a loss of reputation only if communicated to third persons. Here, the only third party allegedly connected to plaintiff's damages that supposedly heard the allegations defamation is Kickstarter. It, however, is a Delaware corporation with headquarters in Brooklyn, New York. Thus, the alleged damages do not occur in Texas. Ooh, that's interesting. We need to get the other whiskey out. We've switched over to the Aaron Malt whiskey with a port cask finish. If you're going to get an Aaron Malt with a finish, get this one. Not the Sauternes cask finish. That tastes like trash. They cost the same, and this one is infinitely better. So don't do that. Failure to state a claim under 12b6. So this is, the argument on the next section. There's no nexus between the defamatory video and the alleged damage because the plaintiff's campaign was canceled before the video. The campaign violated the terms of service of the hosting website. Plaintiff's Kickstarter campaign for the Demonatrix is cited 7 times in the pleading. A copy of the campaign is attached. The exhibit shows that the Kickstarter campaign was not affected by the alleged defamation. It was canceled on March 16, 2021, over a month before the alleged defamation on April 25th. Also, the campaign, which featured pornographic images, was likely canceled because it violated Kickstarter's terms of service, which explicitly forbid pornography. At most, only about 750 people viewed the video. Plaintiffs failed to allege a nexus between the video and a significant circulation of the alleged defamatory statements, which would lead to the alleged stalling of poor sales that forced the campaign's cancellation. And he's quoting those from the complaint, which is great because poor sales that forced the campaign's cancellation could not have occurred from a video that occurred after it canceled, obviously. Also, plaintiffs' allegations such as Kickstarter has shut him down with unreasonable demands are vague and not connected to the alleged defamatory video. Opinions are not actionable. Plaintiffs have failed to plead facts, establishing the requisite elements of their claims against Van Skyver. To this end, plaintiffs have not pled that Van Skyver made a statement of fact that was false and actionable defamation. The two allegedly defamatory statements made by Van Skyver do not relate to or involve defendant John Lamont in any way. Thus, Lamont claims against Van Skyver must also be dismissed in addition to the reasons set forth in the body of this motion in brief. A statement of opinion relating to matters of public concern, which does not contain a provably false factual connotation, will receive full constitutional protection. In other words, if a statement cannot reasonably be interpreted as stating actual facts, it is shielded by the First Amendment. An image of plaintiff's comics, The Demonatrix, appeared in the live stream during the discussion of trademark rights. Defendant's statements were clearly opinions about that image. Supreme Court has held that fictional depictions of children, neither obscene nor child pornography. Ashcroft versus Free Speech Coalition, holding statute prohibiting fictional pornographic images of children overbroad and unconstitutional. So there you go. In addition to showing plaintiffs' actual drawings, the live stream contains several other statements making clear that defendants were merely... the reason they put this in is because it cannot be a fact that the campaign in question is child pornography. It is not. Under Supreme Court jurisprudence, fictional depictions of children are neither obscene nor child pornography. So they couldn't actually be factually child pornography. Does that make sense? Hope you understand. In addition to showing plaintiffs' actual drawings, the live stream contains several other statements making clear the defendants were merely expressing their opinions. For example, Mr. Van Skyver describes a third party as an actual child pornographer, indicating plaintiffs, who are comic book artists, are not actual child pornographers. Also, Mr. Van Skyver's statement, "I don't want Preston to make child pornography," suggests that plaintiff Poulter is currently not making child pornography. Statement is merely Van Skyver's opinion that he would not want pornography on his Comicsgate label. The fact that defendants displayed the image is fatal to plaintiff's cause of action in another way. As the Fourth Circuit noted, because the bases for the conclusions are fully disclosed, no reasonable reader would consider the term anything but the opinion of the author drawn from the circumstances related. An opinion based on an implication arriving from disclosed facts is not actionable when the disclosed facts themselves are not actionable. Finally, we note the obvious. The video was on the YouTube channel Vickyverse and was viewed by about 750 people. There is no allegation that the channel held itself out as a source of facts like a news broadcast or even a YouTube news channel. No reasonable person would cite to a quote on Vickyverse as a factual authority. And this is the Rachel Maddow defense, which was fine when Rachel Maddow used it, but was not fine when Tucker Carlson used it in the media. But it's the proper defense. Rachel Maddow said, no one would take a Rachel Maddow quote and say that it was factual. Tucker Carlson said the same thing because their opinion shows. They are not factual authorities. Their shows aren't built that way. And so that's where this is coming from. Conclusion. For the reasons above, defendant Ethan Van Skyver moves his court to dismiss him from the suit, blah, 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 blah. And so then we have this. This is written by Thomas J. Adair, and he and Scott Houtman are doing this. So then we have some declarations about where these things came from. This is just going to be the lawyer saying, I got these. I got these images and quotes from these sources. That's how they're verified. So that's what this is. Then we've got the Delaware being for Kickstarter. There we go. And then we have a proposed order granting the motion to dismiss. If you ask the court to do something, usually a good idea to include a proposed order, so all they have to do is sign it. So there you go. That is Ethan's motion to dismiss. Motion to dismiss for failure to state a claim and other stuff. So that's great. Now we have DA talks. 53 pages, Dean? Oh my God. Most of it's just exhibits. This is probably going to look pretty similar, though, if I had to guess. And I don't know that I'm going to go through this as thoroughly because most of it we've already seen, right? Remember, by the way, there are people who complain that I don't do this enough. He should just do a law show all the time. Sorry, guys. The law shows do get, they get a little long and boring to me. But here we go. Same thing. Motion to dismiss and brief in support. He has included the table of contents. This looks pretty similar. Similar stuff out here. Personal jurisdiction exists when the defendant purposefully avails himself. Must plead plausible claims. Internet contacts from passive website. This looks really similar. No contacts in Texas. Failure to state a claim under 12b6. God, what is... Man. Let's see. Really similar there. Typically speaking, there is no problem with basically outright plagiarism in legal writing. It's a good move. Dean's like, shit, that was written by some damn pros. Maybe we should modify that one just a little bit. Okay, so he's a citizen of California, domiciled and employed there. Societal commentator on YouTube and social media going by the name DA Talks on his YouTube channel with the same name, specifically speaking on internet personalities and in particular has spoken about plaintiffs who claim to be affiliated with the Comicsgate internet movement. Recently, plaintiff Pegston Poulter has claimed a right to the trademark Comicsgate, which is currently in dispute with defendant Ethan Van Skyver. Plaintiffs state the following about themselves. Here's a section about John T. Lamont is a writer and illustrator of gothic and fantasy comics that are primarily released through the internet and dedicated community chat rooms. Whoa! Look. If there are dedicated community chat rooms for the type of work we've seen from John Lamont, I know where to send the gas. I know where to send it. Just put me in. I know where the gas goes. I have the gas line ready. Pegston Poulter is a publisher, producer, writer, and illustrator of gothic and fantasy comics, and also hosts a web presence called Comicsgate, and hosts a show on YouTube channel, an interactive community that promotes and discusses comics and their authors. Plaintiffs are independent comic book creators who have filed suit against ASF in connection with comments allegedly made by him. Comments were made during either live streams on YouTube or via social media, specifically on the platform Twitter, according to the First Amendment complaint. However, no specificity is provided as to where or when the comments are alleged to have been made. Only the comments were made beginning March 1st, 2021. Here's the problem with the Dean comments. If I'm not mistaken, and credit to Spectre on this. Credit to Spectre, who has been talking about the case with me in DMs, as well as, musing about some things and doing research on this on his own time. I didn't request the research or anything like that, but he's researching it and helping fill me in, which is awesome, and I really appreciate that. If I'm not mistaken, the stuff attributed to Dean was not said on the YouTube video, and wasn't actually ever said. It was just like aggregated comments that were then interpreted in the way Preston wanted to write them, but they're not actually there. Is what I understand. Plaintiffs have not established any facts to support this court as personal jurisdiction over Asaf, and this is interesting to me. I'm really curious to see what the court will do here, because he may have waived this defense, as I discussed earlier, by filing that answer and not asserting personal jurisdiction as a defense in that filing. But again, even if they don't do this, I think he should be fine under the same 12b6 motion. Ken's counseling couch says, please bring me on so I can explain the autismo of Michael Palmer. Isn't Michael Palmer someone in the chat? He is. He is. What do you mean he was never doxxed? He was clearly doxxed. Okay. Anyway, that's a weird argument. But here we go. So on to the factual background. Alleged defamation occurred on a CGDG stream beginning March 1st, 2021, and carried over to April 12th, 2021. So this is different for Dean because beginning March 1st would be prior to the canceling of the Kickstarter, right? Which would happen on March 16th. YouTube maintains a permanent record of such streams and allows for accurate reproduction. However, no stream exists for March 1st, as Asaf did not stream on that day. First stream after the beginning date is March 3rd. Topic of the stream was not Plaintiff Lamont's comic book, but rather the claim document Poulter sent to a DA, a district attorney, to ascertain if he had a valid lawsuit against defendant Ethan Van Skyver for having located public pornographic videos depicting plaintiff Poulter in humiliating and degrading sexual activities. Humiliating and degrading was what he was into. What his wife was into was his anus. Guys, some days you just have to step back and remember that this all started because Preston was into his wife analyzing his sphincter with a dildo and him saying some really funny stuff during it. And look, if that's what you're into, that's cool, man. Let me give you this advice. Pegging, not even once. Not even once. Don't do it. If you do it, don't film it. And if you film it, never put it on the internet. Oh God, it's a multi-step, a multi-phasic process, if you will. Don't do it. If you fail step 1, move to step 2. Don't film it. If you fail step 1 and 2, move to step 3. Don't publish it on the internet. If you fail step 1, 2, and 3, move to step 4. If you have done it, if you have filmed it, if you have uploaded it to the internet, don't ever upload anything else to the internet ever again, unless it's more pegging videos, because once that comes out, that's you forever. That's you forever. So I'm glad he put that in here. Plaintiff Poulter had previously threatened to sue Van Skyver and unaffiliated parties to this case for invasion of privacy for having found these videos and linked them to him. But see, it's not invasion of privacy when you publicly upload them. That'd be like Jenna Jameson, right? Suing the porn studio for invasion of privacy. My vagina was displayed in lewd manner. Okay. Look, I know that you're married to Tito Ortiz now or whatever, but honey, you chose this. You chose it. Plaintiffs also allege that these statements were repeated to an individual named Big Daddy. on a public platform. In this instance, there is no specificity as to where it was said. Who's Big Daddy? Who is Big Daddy? Generalissimo, I read all your $20 chats, but I'm gonna read it again. Nope, you're right. I missed it. Oh shit. He says, Ricada Law, in a totally unrelated subject, have you bought, painted, and used a Primaris-centered squad with heavy flamers? If only they had some sort of degenerate subhuman predator to fight. Too bad about that. I have not. But that would be fun. Sorry for saying the fly. Oh, Jeff Goldblum, you piece of shit. Sorry for saying I read it. I thought I had. I didn't see that one. Who's Big Daddy? I gotta know who Big Daddy is. He's a conspiracy nut who's anti-Trump. Okay. Nick, Ken is not even his name. Or Ken Jennings. I know. Did you see his 6-hour video trying to explain a 2-paragraph redacted email? Then he goes in the chats to make friends with the doxers? You don't understand Ken Jennings. I've met him in person. Nice guy. Nice guy. You should calm down. It's okay. Legal standards. Personal jurisdiction exists when a defendant purposefully avails himself of the privilege and benefits of the forum. And he's got, I mean, this is exactly the same thing. Like this is literally lifted from Ethan's argument. It's the exact same text. Exactly the same. Same citations, same omissions of the citations. Everything in here is perfect. Just yoink. And then this, let's see. This looks the exact same too. So good job. Exact same. This might be different. Nope. This is, oh, here we go. Defendants do not interact with anyone from Texas. They merely speak amongst themselves. 3 individuals outside the forum and 1 as yet unidentified individual, Big Daddy, who has not been shown to be in Texas. So this is a new line that was added. This is all the exact same. Oh, we got a new section. Further, the case Richard C. Meyer versus Mark Wade in the Western District of Texas solidified that a defendant cannot. This isn't a proper citation, Dean. Come on, you gotta cite it. Dean, if you need help with a citation, you can't message me because I can't help you. I'm not your lawyer, but message some other lawyer or buy a blue book. I'm kidding. The judge isn't going to be mad at you. Solidified the defendant cannot be brought into a forum simply for posting on social media or YouTube. In that case, the plaintiff alleged that social media posts by the defendant on the platform Twitter fell under the court's jurisdiction, even though neither the plaintiff nor the defendant asserted that they were made while in Texas or directed specifically to Texas. Indeed, even in this case, the plaintiffs only allege without showing evidence that the alleged statements targeted. Oh, he's got the citation here. You got it here. Why didn't you put it up there? That's not the proper publication citation, but it's better. Indeed, even the case, the plaintiffs only allege without showing evidence that the alleged statements targeted the plaintiffs where they reside and are located and intended that the alleged defamatory statements would damage their reputations locally and nationally in their professions. Lacking these contacts, this court lacks personal jurisdiction. Failure to state a claim under 12b-6. Here we go. Plaintiff's Kickstarter campaign, the Demanatrix, is cited multiple times. According to the Kickstarter campaign, plaintiffs started the campaign on March 15th and canceled the campaign on March 16th, raising only $26 and 1 day of it being available to be funded. 2 true and correct copies of the campaign are attached from Kickstarter. Eldon Bainling, the overwhelming majority of lawsuits are this boring. The overwhelming. This one at least has a Peggy in it. Plaintiff Lamont took the campaign down with the following reason on March 16th. Thank you all very much for your interest in the Demanatrix. Please do not be alarmed. but I will withdraw the campaign and lowering the funding amount to $500. This will assist in meeting our funding goal and help put copies of the books into your hand. I'll post another update once the process is complete. I look forward to seeing you back. Cheers. Plaintiff Lamont makes no mention of why he took the campaign down, except to say that he was lowering the goal by 50%, making no mention of any commentary made by defendants nor any actions on their part to have it removed. However, Kickstarter's terms of service prevents campaigns featuring pornographic materials from being presented on their platform, putting Plaintiff Lamont in violation of their own rules, which would have led to inevitable cancellation, if not being the ultimate reason it was canceled to begin with, and why Kickstarter refused to allow Plaintiff Lamont to renew it. True and correct copy of an archive screenshot is attached. As stated previously, there is no YouTube live stream on ASAF's channel for March 1st. Further, there is no specificity with regards to when statements were made, where they were made, whom they were made, aside from between the defendants. Indeed, the plaintiffs allege only that the statements were made beginning March 1st, continued to April 21st, and finally to April 25th on a public platform. There's no mention of where exactly or when these statements were made beyond that, which is important. Again, you can't just say statements were made. Where were they made? To whom? Using what medium? Plaintiffs allege that ASAF had appeared on a public platform with an individual known as Big Daddy on April 12th, but failed to inform this court of what platform this was. Lacking any type of specificity in the issue, the logical conclusion is that plaintiffs wish to waste time with the defendants, their counsel, and the court by requiring everyone but themselves to do the work for them. This is getting a little bit when no party other than the plaintiffs are required to do such a thing. Look, saying that you went on to a show with Big Daddy on April 12th is pretty specific. And if it just was on YouTube, but they didn't mention on YouTube, or if it was on Twitch or Odyssey or something, but they didn't mention it, I don't know if that's sufficient enough to dismiss it. And this is a little grandstandy for me, but that's fine. Aside from the April 25th allegation, defendants cannot properly defend themselves. They have no idea of when and where to look to ascertain the validity of the claims made. I'll stick with you that if they don't actually say what was said, then they have failed already. And the defendant should not be burdened with what the due diligence of the plaintiff should have been. The main thing is they don't say what was said. Answer EVS's question. I want to know too. Where's his question? Shit. Can I sue DA Talks for stealing my filing? Will he get jail time? You could sue him, because you could sue anybody for anything. But I don't think you would prevail, and no, he won't get jail time. He has changed a good amount. He's added his own bits here. I mean, he did completely yoink some of your filing, though. That's pretty funny. Plaintiffs allege that Poulter's most recent campaign suffered a 20% drop in average funding contributions from the last major campaign in November of 2020, but offered no evidence to support this claim. Indeed, Poulter's April campaign for Guinevere and the Divine Factory No. 4 mega campaign has an update stating, "Thanks to all your support, this campaign turned out to be my best launch yet. As the campaign nears its first 24 hours on Kickstarter, it has made over 60% of the $5,000 goal. Campaign raised $10,171, 203% of its $5,000 goal." See Appendix 15 to 16, Exhibit 5. Plaintiff Poulter's most recent campaign for Guinevere and the Divine Factory No. 5 trade paperback has made $10,982 on August 17, 2021, with 8 days remaining in the campaign. Plaintiff's November campaign for White Lily trade paperback, 164 full color pages, made $5,424 in total. True and correct copies of the campaigns, including a similar update, are attached. It seems contrary to plaintiff's claims, these campaigns by Plaintiff Poulter have instead made more than the previous campaign. I wish I could kill this fly. With Plaintiff Poulter bragging about its success at the very first update. He continues to attend conventions without worry. Look, I mean, he might, but let me humbly suggest that that at least one convention he might not be welcome back at. But maybe I'm wrong on that. Plaintiff Poulter has attended 3 conventions this year to sell his works in person: North Texas RPG Con in Irving, Texas, Albuquerque Comic Con in Albuquerque, New Mexico, and Anime Matsuri in Houston, Texas. At both North Texas RPG and Anime Matsuri, Poulter appeared to be in good spirits with no private security and visible attendance. Plaintiff Poulter also made posts on Twitter bragging about the amount of sales he was making at all 3 conventions. That braggadocio may not be... you know what? Good for him. Good for him. I did see him at Anime Matsuri. I did not go talk to him. I do not interfere with people in person and certainly not in their business. But I did see him physically. So there was that. I also know someone who received free copies of some of his comic books. They did not know who he was. So that also happened. Let's see. Taking into account what was said previously about Poulter misrepresenting in the complaint the amount of money made between his November campaign and his most recent campaign as of April 2021 when the suit was filed, serious questions arise over whether Poulter has lost any money. For the reasons above, ASF moves to dismiss him from the suit because the court lacks jurisdiction and to dismiss the suit in its entirety because of 12b6. There you go. And there are a ton of exhibits. Man, I would not want to have my picture taken for having these, for getting his books here. So there you go. Got all these poor people getting Preston's books. The real question is how many he was giving away for free. Because, again, I know some of these were given away for free at Matsuri. But he's talking about sales here. Very interesting. Very interesting. Have to maybe go check. That would be, yeah, so here's all these people getting pictures. Oh, he's got a cost thought in this one. Almost triple my table fee on credit card sales alone. Okay. So there you go. I thought the table fees at Matsuri were more than $250, but maybe that was probably for the main floor. So there we go. That's Pocket Jacks Comics. Here's all this stuff that we've got. Okay. So that's Dean's motion to dismiss. It's fine. He took most of the legal arguments directly from Ethan, which was a smart thing to do. It was a smart thing to do because, you know, Ethan's lawyer wrote a good brief. Let me pull up the responses. The response to EVS's motion to dismiss. Here we go. Woohoo! All right, so the 22 pages. Why, Preston? All right. Just draw a farm bigot. Oh, God. You know what I'm excited for today, guys? It's the Microsoft Surface event today on the 22nd of September. Later today, I'll be watching. Well, I won't be watching the event, but I'll be watching for the product releases. Hopefully, they upgrade this fucking Surface Duo into a good phone. That would be great. And then I'm looking. I like the Surface line of products. I'm looking to see what they do. They're supposed to announce a lot of stuff. New Surface 8, I think. Surface Tablet 8. Hopefully a new Surface Pro X. New Surface Duo 2. I'm hoping they have a Surface Studio 3. We'll see. We'll see. Okay. Plaintiff's response to defendant Ethan Van Skyver's motion to dismiss and brief in support. All right, so he's got the table of contents and authorities, a response brief, factual background. Oh, God. This is going to be horrifying. Plaintiff John T. Lamont and Pegston Poulter sued defendants Dean Asaf, Victoria Kundert. We know all this, right? And Ethan Van Skyver for defamation arising out of a series of conversations broadcast on YouTube. Asaf has appeared and consented to this court's jurisdiction. See, this is the problem with that answer, like I talked about earlier. Kundert is evading service. This is not true. You have not actually served Vicky Verse at her address. You served at an address. I think she hasn't been at that address for something like 20 years. That's your fault, you dummy. Evading service that's a pretty serious thing to allege, especially when someone has done nothing to evade the service at all. Van Skyver moved to dismiss for lack of personal jurisdiction, failure to state a claim. Court should deny Van Skyver's motion because he picked a fight in Texas and he should be required to settle it in Texas, and because calling someone a pedophile and child pornographer is actionable as defamation. He didn't call you a pedophile or a child pornographer. But if it's true, it's not defamation. And if it's an opinion rather than a fact, it's not defamation. Factual background. Pegston Poulter and Ethan Van Skyver are both well-known figures in the independent comics community. I mean, that's a stretch. That's a stretch. Adam Krigler, you can't crash this party tonight. You can't do it. Adam, you can't be bored yet. Adam Krigler, do you know that this case involves a man who laid on his back, pulled his knees gingerly to his chest, and let his wife ram a giant phallic object into his anus? Did you know that? Amongst other severely degrading acts. Not only did he do that, he did it on video. And he uploaded those videos to the internet. Don't tell me you're bored. Don't tell me you're bored. You don't get to find this anywhere else. Okay. Poulter is based out of Dallas, Texas, and Van Skyver is based out of New Jersey. They're engaged in a lengthy and public fight for control of the Comicsgate mark. No, Poulter's trying to steal the mark. Poulter registered the mark first, but Van Skyver claims to have a common law right to it, because he does. Those issues are being litigated before the Trademark Trial and Appeal Board, but Van Skyver and his allies have taken the fight to the public forum. I mean, the trademark and the Patent Trademark Board is also a public forum, just to be clear. On April 25th, 2021, Van Skyver appeared on a talk show hosted by defendants Dean Asaf and Victoria Kundert on YouTube. On the talk show, Van Skyver made the following statements about Poulter's use of the Comicsgate seal on a comics series developed by plaintiff John Lamont. But I mean, you know, my side of things is that it's pretty demonstrable that Comicsgate has been used in commerce by me and me alone up until Preston decided he would try to spite trademark the term. I was told this by another trademark attorney that, look, you have been using Comicsgate in commerce. You have what's known as a common law mark to the word. You don't need to register it. I mean, you don't need to register it. Doesn't need to happen. You are the trademark owner. I don't think anybody is going to be attitudinal about it. Just don't think anybody's going to be very upset. And I think that I'm, co-opting a movement. All these accusations have already been made and put into play, and they amounted to nothing. So I don't want Preston to make child pornography and put Comicsgate on the label. You know what I mean? Yeah, that was a pretty fucking gross move. Especially right now, at this point, one of his pals, Slick Jimmy, outed as an actual, child pornographer, pedophile. It's like this. Now is not a good time for that bullshit. In order to have a trademark, you have to protect it. So I will protect it in that way. I will not allow it to be put on child pornography by Pegston Poulter. There you go. Perfectly done. Perfectly done. Those statements are not defamatory. As a result of Van Skyver's false statements, Lamont and Poulter have suffered losses of sales and income and have been forced to incur increased expenses for personal security and mental health treatment. What mental health treatment? Did they fix you? Are you no longer trying to sell pedophilic comics? Like, have you stopped? Did you stop, though? Lamont and Poulter initiated this lawsuit on May 23rd. Van Skyver was served on July 14th. Van Skyver filed the instant motion to dismiss on August 4th. The court issued a briefing order on August 13th. Van Skyver moved to dismiss this lawsuit on two basic grounds: lack of personal jurisdiction and failure to state a claim. For the reasons set forth below, both arguments fail. Dun, dun, dun. This court has personal jurisdiction over Van Skyver. He picked a fight in Texas by calling someone he knew to be a Texas resident a pedophile and child pornographer, intending to cause him harm in Texas. Law compels him to settle the fight here. This is a shit argument. Look, if I call someone from Texas right now a pedophile, that does not mean I'm going to Texas to call them a pedophile. That's not what happens. That's not how that works. That's not how jurisdiction is sussed out in court. That is not a claim for personal jurisdiction. You'd have to show, again, that they intentionally reached into Texas to do so. Had he called up someone in Texas, had anybody on the call been in Texas, had they contacted a Texas newspaper, any of those things would have been bringing it to Texas. Other than that, just saying it out loud does not make you liable in Texas. It doesn't work that way. Van Skyver picked a fight in Texas, and that fight should be settled in Texas. And again, in Meyer versus Wade, we saw that there was no jurisdiction over comments made broadly online on Twitter, right? Despite the fact that those actually did cause Richard Meyer damage in Texas, because his contract that was canceled was between him and a Texas company. But the judge did find that Wade calling the company in Texas to interfere with the contract and statements that were made about Meyer in Texas at a convention, those things were under Texas personal jurisdiction, or would bring Wade under personal jurisdiction for those actions. And this is where Preston's just wrong here. And they've always been wrong. Wait a minute. Oh, I still say Mandy Caravicius' name wrong. Look, I'm a humble chicken guitar player. I can't be expected to pronounce everything correctly. I'm out here just trying to get these chickens to lay eggs with my humble guitar strumming skills. I do have the 1K drink poured. Federal court sitting in diversity jurisdiction may exercise personal jurisdiction over a foreign defendant if the long-arm statute creates personal jurisdiction. The exercise of personal jurisdiction is consistent with the due process guarantees of the Constitution. Blah, blah, blah. This is exactly with the same thing that Ethan Van Skyver typed, right? Due process permits a court to exercise personal jurisdiction over a foreign defendant when that defendant has purposely availed himself of the benefits and protections of the forum state by establishing minimum contacts with the forum state, and the exercise of jurisdiction over that defendant does not offend traditional notions of fair play and substantial justice. Defendant's contacts with the forum state will give rise to either specific or general jurisdiction. General jurisdiction exists when a defendant's contacts with the forum state are unrelated to the cause of action but are continuous and systematic. Specific jurisdiction arises when the defendant's contacts with the forum arise from or are directly related to the cause of action. Okay, there's no general jurisdiction because he doesn't have continuous and systematic context, so he's going to go to specific rules, personal jurisdiction in internet defamation cases. To determine whether it can exercise specific jurisdiction, the court should look only to the contact out of which the cause of action arises. In intentional tort cases, a single act by a defendant can be enough to confer personal jurisdiction if that act gives rise to the claim being asserted. When the actual content of communications with a forum gives rise to intentional tort cause of action, this alone constitutes purposeful availment. However, there isn't actual communication with the forum. The defendant is purposefully availing himself of the privilege of causing a consequence in Texas, but there wasn't communication with the forum here. There's no communication with Texas going on. In the case at bar, the court's jurisdiction over Van Skyver arises out of his defamatory statements about Lamont and Poulter, which were published on the internet via YouTube. In defamation cases, including internet defamation cases, a Texas court may exercise specific jurisdiction over a non-Texas defendant who has expressly aimed his defamatory statements at a Texas plaintiff. There's Calder v. Jones. The Supreme Court adopted the effects test for personal jurisdiction defamation cases. The Florida defendants' intentionally and allegedly tortious actions were expressly aimed at California. Calder v. Jones is not the case for you, Preston. Petitioner South wrote and Petitioner Calder edited an article that they knew would have a potentially devastating impact upon the respondent. And they knew that the brunt of that injury would be felt by respondent in the state in which she lives and works, in which the National Enquirer has its largest circulation. Under the circumstances, petitioners must reasonably anticipate being hailed into court there. Yes, because they sent thousands and thousands and thousands of copies of the National Enquirer. They shipped them in boxes on trucks and trains into California. They said, we're going to publish this article, and we're going to send a whole shitload of those into California. That's how they got personal jurisdiction, you moron. They didn't just broadcast it and someone... You haven't even alleged that someone from Texas watched the broadcast other than you. Under the circumstances, petitioners must reasonably anticipate being held into court there to answer for the truth of the statements made in their article. An individual injured in California need not go to Florida to seek redress from persons who, though remaining in Florida, knowingly caused the injury in California. Because they sent thousands of copies of the Enquirer to California. More than they would send to any other state by a lot. It wasn't just a little. It was a lot. Under the Calder test, a plaintiff's contacts with the forum state may be so manifold as to permit jurisdiction when it would not exist in their absence. Again, this isn't Calder. This is nothing like Calder. Calder test works very well in internet defamation cases. For example, in Haubecker versus Hall, Judge Rodriguez of the Western District of Texas determined that this court had personal jurisdiction over a Pennsylvania resident who posted messages on Facebook about a Texas resident. Hall apparently knew Haubecker lives in Texas, and the focal point or effects of her allegations were designed to be felt in Texas by Haubecker. Taking Haubecker's allegations as true for the purpose of answering this jurisdictional question, Hall expressly aimed online contacts to Texas residents and intended the focal point and brunt of her posts and interactions to be felt by Haubecker in Texas. Therefore, specific jurisdiction over Hall is proper because she had sufficient minimum contacts with Texas. You didn't allege that, and you can't allege that. They didn't target their thing towards Texas. I don't know the facts in Haubecker versus Hall, but I'd be curious to see if they were posting them, tagging her on Facebook, where her friends who are in Texas would see the tagging. Her, his, I don't know who it is. In another case, Judge Fallon of the Eastern District of Louisiana held that his court had personal jurisdiction over a foreign defendant who posted numerous defamatory statements on several websites referring to sexual and other misconduct by the plaintiffs. Judge Fallon found that the subject matter of the statements was in Louisiana, the sources relied upon for the statements were in Louisiana, and that the defendant knew that the brunt of the harm would be felt in Louisiana because the defendant knew that the plaintiff lived and worked there. You've got sources, you've got the subject matter in Louisiana. Again, this is I'm curious about these, but what the actual facts underlying this is. Southern U.S. Trade Association versus unidentified parties. Judge Fallon's analysis in SUSTA addresses a few factors that are either irrelevant or non-determinative. First, Calder does not require the defamatory statements to explicitly or specifically refer to the forum state. Second, Calder does not require the harm to be exclusively felt in the forum state. Noting that the Supreme Court clearly found it irrelevant that the victim, who is of national renown, almost certainly had a reputation to protect outside California. Again, this is Calder. But again, in Calder, they mailed thousands of documents to California with the defamatory material. Third, the share of the audience in the forum state is not relevant. Noting that the defendants in Calder published their statements in a national magazine that had only about 1/10 of its circulation in California. Yes, it's a national magazine with 1/10 of its circulation in 1 out of 50 states. I mean, that's pretty fucking significant, you dummy. And finally, the Zippo spectrum is not determinative in internet defamation cases where the defaming defendant does not operate the website. In sum, the test for personal jurisdiction in internet defamation cases is, in the main, a pragmatic account of reasonable expectations. If you're going to pick a fight in Texas, it is reasonable to expect that it be settled there, citing Revel. But again, this is Meyer versus Wade in a different way. In Meyer versus Wade, Wade picked up a phone and dialed the Texas phone number. This didn't happen here. These are just generally broadcast to anybody. And you haven't actually shown that damage occurred in Texas or was intended to occur in Texas. Van Skyver's contacts in Texas. Van Skyver expressly aimed his defamation in Texas. He knew that Poulter lived and worked in Texas. When he called Poulter a pedophile and child pornographer, he knew and intended that the brunt of the harm would be felt in Texas. Those are all conclusions, by the way. Those are not actually factual assertions. Under the rule in Calder, that contact alone is sufficient for this court to exercise personal jurisdiction over him. Man, I'm really curious. This is bothering me. Let me see something real quick. Whoops. I want to see very briefly what this case is about. Let's see. Hawbecker alleged that defendant Hall made knowingly false statements on Facebook and to his employer about Hawbecker sexually abusing children and possessing sexually explicit photos of children. He granted summary judgment to Hawbecker on the issue of liability, finding that Hawbecker had established as a matter of law all elements of his cause of action for defamation per se, and that Ms. Hall had failed to establish any defense to her statements. Yeah, she contacted his employer directly on Facebook. That's pretty fucking different, you dummy. This is what happens when you let people who wear helmets to type get access to a legal filing. I won't even look up the Susta one. It doesn't matter. If he's misrepresenting Hawbecker versus Hull, he's misrepresenting Susta as well. Pretty simple. The fair play and substantial justice factors weigh in favor of exercising personal jurisdiction. Having established that Van Skyver has sufficient minimum contacts, you've done no such thing. The next question is whether doing so would offend traditional notions of fair play and substantial justice. Courts generally recognize 5 factors relevant to this determination. Burden on the defendant, the forum state's interest in adjudicating the dispute, plaintiff's interest in obtaining convenient and effective relief, the interstate judicial system's interest in obtaining the most efficient resolution, and the shared interests of the several states. I'm not going to read this argument because if Van Skyver has sufficient Texas contacts, then he definitely, it is definitely fair to bring him to Texas. The problem with it is you fail at the first test. You don't have sufficient contacts between Van Skyver and Texas, as alleged in this lawsuit. I don't know everything about Ethan. I don't know if he goes and takes a dump in Texas every 6 years. I don't know what he does, right? I have no idea. But they haven't properly alleged any of that. So what you're saying is, we have it. Now the substantial notions of fair play and justice. Look, if he has sufficient contacts, then it's perfectly fair to bring him to Texas for the alleged tort. There's nothing that would offend the notions of justice. So I'm going to skip this section because it's going to be too long. So here we go. Here he's directly addressing Van Skyver. Van Skyver's motion to dismiss relies on several faulty premises. First, Van Skyver relies in part on the unsupported conclusory statement by his lawyer that he has not had any significant contact with Texas. I mean, that's not an unsupported conclusory statement. First of all, the burden is on the plaintiff to show the significant contacts. The burden is on the plaintiff to do so. It is not on the defendant. Second, you can't prove a negative. It's not possible for him to say in any other way that he doesn't have any significant contacts with Texas. What else is he supposed to say? He can't argue against contacts that don't exist. It's like, well, he didn't go to Texas in 1996. He didn't go to Texas in 1997. He didn't go to Texas in 1998. He did not make a phone call to Texas in 2016. This is a nonsense claim. But as the Lewis court explained, the minimum contacts analysis is not a math test. A single contact, such as a false statement claiming that a Texas resident is a pedophile and child pornographer, can be enough. Can be. if it's made to someone in Texas or if it's made in Texas. Second, Van Skyver relies in part on the conclusory statement by his lawyer that the alleged defamatory video is not directed to Texas. No, again, it's your burden. This is written by a lawyer, y'all. A lawyer who is struggling to write this. But that is the question to be answered. No, you can't. It's not a question to be answered. You have to assert it. You have to put forth. It's your burden to show that it was directed to Texas. How was it directed to Texas? Did he tag Texas on the YouTube video? Did they call someone in Texas on the air? Did they send a copy of this to Governor Abbott? What did they do to target Texas? All you have to do is allege anything that they did, and you can't. You just said, well, they said it. They didn't, but that's not good enough. But if they had tagged, like if the video has as the tags that we put in the metadata for YouTube when you upload something, if you go in and put in Texas and then tag it to like Austin, Texas or something, or like Poulter's hometown, whatever that is, you did that, you would then have a claim. Maybe that would be enough. I haven't actually seen a case that analyzes that, but that might be purposefully directing it at Texas. If you did an advertisement on the live stream, then that might be, that might be a claim that this was done in Texas. An advertisement for a Texas company, for example. And speaking of advertisements, might I remind you guys that Ridge Wallet is a sponsor of this show. I don't know where Ridge Wallet is based. I just know that they are based. They are based and knife-pilled and wallet-pilled, and they sell really, really good products. And I want to remind people that you can actually buy some of these products at ridge.com/nose and use promo code NOSE to get yourself one of those sweet, sweet little discounts. Now, I'm doing this ad specifically on this program to discuss that if, for example, Ridge Wallets were based in Texas, I don't think they are, but if they were based in Texas, and if Vickyverse had gotten a sponsorship from Ridge Wallet, and if Vickyverse had sponsored and done that Ridge Wallet ad, and they had said, you know what, Ridge is a great Texas company. Again, I don't know where they're from. It doesn't matter. They make good wallets. You should buy one. If she had done something like I'm doing right now and shamelessly shilled Ridge Wallets during this stream about Peggy Poulter, about a man getting pegged on the internet for money and then being mad about it years later. If they had done that to Ridge Wallet, it would be, one, cruel to Ridge Wallet to do that. But two, it might actually be purposefully directing acts towards Texas, because if, hypothetically, Ridge Wallet were a Texas company, then they would be including Texas in their nexus of events that was going on. None of this happened. And this, by the way, is just another brilliant ad for Ridge Wallet here on this channel. I am a firm believer in the Ridge Wallet. I've been using one for several years now. I think it is a fantastic product. I use it every day. My dad recently purchased one using promo code NOSE. In fact, I pulled out my Ridge Wallet at Qdoba the other day, and the guy said, "Hey, is that a Ridge? Is that a Ridge Wallet?" And I was like, "Yeah, buddy." He goes, "Is that the Ember Wallet?" And I was like, "Yes." And he's like, Yeah, I got a Ridge Wallet. I really like it." And what he said, and I support this, he was a pleb. He said he got the money strap. He's like, "I should have gotten the clip." I agree. You should get the money clip when you get your Ridge Wallet, because the money clip is a little bit more wieldy. The strap seems cool because it seems sleek and smaller profile, but in the end, trust me, get the clip. It's a better thing. But if you want to get noticed at a Qdoba, I don't know, maybe you're looking for love. You want to get noticed at a Qdoba, put yourself in the position of having a Ridge Wallet to whip out that slew of credit cards and be like, "Hey, what's up, Qdoba register person? I got this wallet for you." Bam. There's that debit card. you go ahead and charge that burrito, right? You can go ahead and do that, and you will get all the love and attention you need because you had a Ridge wallet and you use promo code NOSE. So there you go. There we go. We've made an informative grift using Ridge wallet. I strongly recommend, in all sincerity, I really do recommend Ridge wallets. That's not a joke. But this is instructive because had they done something like that, advertised to a Texas company on the live stream, that would be putting themselves in the position of availing themselves of Texas Forum, of the Texas Forum. That's not what happened here. That's not what happened here. There's no way that they have shown that the video was directed at Texas. And they really needed to do that work, and they haven't done it yet. If, like the defendants in Calder, Habecker, and Susta, Habecker is not your case. In Habecker, they sent the messages on Facebook to a Texas employer. They're intentionally reaching into the guy's employment contract in Texas. That's way different. Van Skyver made statements about somebody he knew was a Texas resident with knowledge that the brunt of the harm would be felt there. Then he directed his statements to Texas. Third, Van Skyver relies in part. Some degrees of sundown. You use promo code MAJORKILL? What is wrong with you? I like Major Kill, but I'm going to come and uppercut you in the nuts. What is this? Return it and immediately use promo code NOSE. Third, Van Skyver relies in part on the Zippo test, arguing that YouTube is a passive website and that hearing Van Skyver's statements required the unilateral activity of non-party viewers. But as Judge Fallon in the Revel Court explained, the Zippo test is not determinative in internet defamation cases where the defendant did not operate the website on which the statements were posted. Finally, Van Skyver relies in part on the premise that the only third party allegedly connected to plaintiff's damages that supposedly heard the alleged defamation is Kickstarter. But Poulter and Lamont's damages are not limited to the cancellation of the Kickstarter campaign. They include damages caused by people hearing and believing Van Skyver's lies, including publishers refusing to sell Poulter and Lamont's comic books. Are those publishers in Texas? Are the publishers in Texas? Customers refusing to buy Poulter and Lamont's comic books. Are they in Texas? You haven't even alleged that they're in Texas. The need for additional security at comic book conventions and gatherings. Those are in Texas, the ones that you've attended, but you didn't actually have additional security at those conventions and gatherings, did you, you liar? You're lying to the court, but that's okay. Because again, I did see Preston and his table. There was no security present. At Matsuri, one of the single biggest conventions, definitely the biggest convention that he attended, and one of the biggest conventions in the country, they didn't have any security there. So where was it? And plaintiff's mental anguish suffered as a result of those injuries. Do you have the bills? Do you have proof of your mental anguish? Have you documented it? In other words, the brunt of the harm caused by Van Skyver's statements was felt and intended to be felt in Texas. Court can exercise personal jurisdiction over Van Skyver. Van Skyver made defamatory statements about someone he knew was a Texas resident with knowledge and intent that the brunt of the harm would be felt in Texas. This is the conclusory statement, by the way. The court should deny the motion to dismiss and exercise jurisdiction. Preston, if they do that, you're gonna lose here. But they probably are gonna say they don't have jurisdiction. If I had to guess. Rule 12b-6 authorizes the dismissal of cases. When the complaint fails to state a claim upon which relief can be granted, the basis of the motion can be either legal or factual. Legal basis applies where the plaintiff would not be entitled to relief even if everything he alleged were true. That's this one. The factual basis applies where the complaint does not contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. This is also that one. Plausibility is not akin to a probability requirement. A well-pled complaint may proceed even if it appears that recovery is very remote and unlikely. You didn't file a well-pleaded complaint. In evaluating motions to dismiss filed under Rule 12b-6, the court must accept all well-pleaded facts as true and view them in the light most favorable to the plaintiffs. All questions of fact and any ambiguities in the controlling substantive law must be resolved in the plaintiff's favor. In determining whether a plaintiff's claims survive a Rule 12b-6 motion to dismiss, the factual information to which the court addresses its inquiry is limited to the facts set forth in the complaint, documents attached to the complaint, and matters to which judicial notice may be taken under the Federal Rule of Evidence 201. Lamont and Poulter stated claims against Ethan Van Skyver. Lamont and Poulter sued Van Skyver for defamation, slander per se, and cyber libel and statutory libel. The basic elements of a claim for defamation are a publication of a false statement of fact to a third party that was defamatory concerning the plaintiff and was made with the requisite degree of fault. That's quoting Dallas Morning News versus Hall. Lamont and Poulter have pled sufficient facts to show a plausible claim that Ethan Van Skyver defamed them. Lamont and Poulter allege that Van Skyver intentionally or negligently made statements to a public audience on YouTube that were about Lamont and Poulter, indeed that referred to them by name, that were apparently statements of fact, specifically that Lamont and Poulter were pedophiles and pornographers, and that were false. Lamont and Poulter, who also alleged that as a result of Van Skyver's false statements, they suffered general reputational damages as well as special damages, including lost sales and income from publishers refusing to sell Poulter and Lamont's comic books, lost sales and income from customers refusing to buy Poulter and Lamont's comic books, and the need for additional security at comic book conventions and gatherings, and plaintiffs' mental anguish suffered as a result of those. Footnote 6, Texas law recognizes defamation in two forms: slander, a defamatory statement expressed orally, and libel, a defamatory statement expressed in written or other graphic form. Lamont and Poulter's complaints stated a claim upon which relief can be granted and the motion should be denied. It didn't. It didn't, and they don't say how it did, so that's good. Good job. Writing a bunch, but not actually making your argument. Van Skyver's arguments otherwise are based on faulty premises. Van Skyver makes two arguments ostensibly under Rule 12b-6 that the alleged damages were incurred prior to the defamation, that Van Skyver's statements were merely opinions and thus not actionable. I mean, that's not a faulty premise. That's a really important premise in defamation law. Also, this would be too. You can disagree with the premise, but that doesn't make it faulty. First, Van Skyver construes Lamont and Poulter's claims for damages too narrowly. No, you construed them too narrowly. Van Skyver seems to think that Lamont and Poulter's only claim for damages is a cancellation of the Kickstarter campaign. It bears noting that, according to the complaint, Van Skyver's co-defendants made defamatory statements about Lamont and Poulter prior to the cancellation. It doesn't bear noting. This actually doesn't bear noting in regards to Van Skyver. It would bear noting in regards to Dean, but not to Van Skyver, because he didn't make those statements. So it doesn't bear noting. But Lamont and Poulter have alleged that they anticipate continuing to suffer damages. They anticipate continuing to suffer damages from Van Skyver's statements for at least the next 3 years. Well, I'm sorry, but anticipating damages is not damages. I anticipate to lose money in the future. Oh, do you? Including future lost sales and income, mental anguish, the cost of counseling and therapy, and the increased cost of personal security. Much of these damages were and will be incurred after Van Skyver's defamatory statements. Second, Van Skyver's statements that Lamont and Poulter are pedophiles and child pornographers are actionable. He argues that his statements are privileged because he was merely expressing his opinions, and he displayed some drawings made by Lamont. But the Supreme Court has rejected the artificial dichotomy between opinion and fact. Yeah, that means you can't just say, look, it's my opinion that Pegston Poulter is definitely having sex with children. Like, you can't just do that, right? Like, you can't say, oh, it's my opinion that defamatory statement. There's a difference. Actually expressing opinions, like, oh, man, kind of looks like Preston wants to have sex with kids. Like, if I say that, that's an opinion based on the thing that's happening in front of me. But if I say, look, it's just my opinion that Pegston Poulter is definitely having sex with kids, me saying it's just my opinion doesn't make it just an opinion. If I'm clearly trying to get the assertion of fact out there that that's what's happening. Obviously, these statements are made in the hypothetical for the purposes of education, and Preston, if you sue me, get fucked. I mean, wait. No, you'd like that. You already did that. Preston, if you sue me, I will... Preston, if you sue me, you will get reamed out. Fuck! How do I threaten this man? How do I threaten that which has already been pegged? Instead, the question is whether the statement is verifiable as false and whether the entire context in which it was made discloses that it is merely opinion masquerading as a fact. Van Skyver's statements are verifiable as false, and their context shows that he made them as assertions of fact. I mean, I don't think so, but okay. Van Skyver was discussing the fact that Preston placed his Comicsgate seal on Lamont's comic book series. Yeah, you did do that. That is a factual statement that is true. The Demonatrix. Van Skyver objected to placing the Comics Gate seal on the Dominatrix because. But you placing him saying he put the Comics Gate seal on Lamont's comic book series isn't the defamatory statement in question. Van Skyver says, I don't want Preston to make child pornography and put Comics Gate on the label. You know what I mean? I'll not allow it to be put on child pornography by Preston Poulter. Blah, 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 blah. Slick Jimmy was an actual child pornographer and pedophile. Who's Slick Jimmy? Besides an actual pedophile and child pornographer. Who's that? Is that a friend of Preston's? I don't know anything about Slick Jimmy. Van Skyver's statements about Lamont and Poulter are like the, in my opinion, John Jones is a liar example discussed by the Supreme Court in Milkovich. It's not. It's not at all. By saying that, the speaker implies a knowledge of facts which lead to the conclusion that Jones told an untruth, even if the speaker states the facts upon which he bases his opinion. If those facts are either incorrect or incomplete, or if his assessment of them is erroneous, the statement may still imply a false assertion of fact. Simply couching such statements in terms of opinion does not dispel these implications. And a statement, in my opinion, Jones is a liar, can cause as much damage to reputation as a statement, Jones is a liar. They didn't say, in my opinion. They're not trying to couch it that way. It's just pretty obvious that, first of all, he doesn't even issue an opinion that President Poulter is a child pornographer or a pedophile. He just says he doesn't want that to happen. I'd say it's almost more of a hypothetical than an opinion about Poulter or a statement about Poulter in general. Just so here, Van Skyver showed a few images and made broad statements. The problem you've got here, Preston, is that he's showing the images and deriving an opinion from those images in real time. Like that's happening. That is a problem for your argument. Bolstered by the allegation that Poulter was associated with an actual, child pornographer, pedophile. Van Skyver clearly intended to make or imply a false assertion of fact about Lamont and Poulter. Van Skyver's statements are therefore actionable, and the motion to dismiss should be denied. Perhaps ironically, Van Skyver himself has faced criticism in the community for collaborating with and defending another comic book creator, Dave Sims. Van Skyver apparently defended Sims' relationship with a 14-year-old girl, comparing it to Elvis Presley's relationship with Priscilla. See Wikipedia's article about Van Skyver. Uh-oh! Ethan! Did you defend Dave Sims having a pedophilic relationship with a 14-year-old girl? Conclusion, the court should deny Van Skyver's motion to dismiss in its entirety. First, the court has personal jurisdiction over Van Skyver because his defamatory statements about somebody he knew to be a Texas resident made with the intent to cause harm in Texas are sufficient to contacts with Texas for the courts of Texas to exercise personal jurisdiction. No, they're not. No, they're not. He says, not really, no. He didn't do it. He didn't do it. Exercising personal jurisdiction over Van Skyver will not offend traditional notions of fair play and substantial justice. That's only true if the minimum contacts are made. Should the court be inclined otherwise, however, plaintiffs would request leave to file a motion to transfer the case to another district, which may be able to exercise personal jurisdiction. They wouldn't let you move to transfer the case to another district. They would dismiss the case without prejudice, and you would refile it in that district. Because you're not going to bring Dean and Vickyverse into New Jersey. That's not going to work out for you. Second, Lamont and Poulter stated claims upon which relief can be granted. Court should therefore deny Van Skyver's motion, grant plaintiffs such other and further relief to which they may be entitled. Jeremy Maston, look, from the Ahmed firm, I don't know these guys. The complaint is written competently. They've got a shit argument, but they've got a shit set of facts. They've got Pegston Poulter trying to publish a pedo comic. I mean, that's their first problem. Oh, damn it. Let's see. Here's the... Other one we've got here. Holy fuck. Preston, why are you filing 71 pages of fucking documents against Dean? 71 pages for what? Cost me $7 to buy this goddamn document. Oh my God, I'm going to go poor. I'm going to be a poor. Shit. Okay, same stuff. Van Skyver's allies, Dean Asaf. Oh, Ethan, did you know that you are allied now with DA Talks forever? You guys are hand jobbing under the table constantly. Yeah, that's right. Allies for life. Defendants Dean and Victoria are allies of Van Skyver. Yes, this Vickyverse, who tried to get Van Skyver in trouble for false advertisement and claims of deceptive trade practices. Huge ally of Ethan Van Skyver. The biggest of allies. Really wonderful allies. Tremendous allies. Have you ever had allies like this? Ones that try and get you in trouble? In trouble for false advertising and deceptive trade practice? Really, what better allies are there than ones who try to get you into jail for criminal acts? Those are the best kind of allies. Wonderful ally. I've seen lots of allies that are out there, and these are the best allies you got. Okay. They're now allies with Ethan. There's a show called The Comics Gate Dumping Ground. Asaf and Kunder use their show to broadcast claims that plaintiff John T. Lamont is a pedophile who's making fucking B pedophile comics. I don't know what that means. And child porn. They asked for them to be ostracized from society and shot. Those are just like opinions, bro. Asaf and Kundert also claim that Poulter engaged in the same activities, i.e. being a pedophile and making pedophilic comics and child pornography. They had Van Skyver on their show. This is the same shit. I don't know if I want to go through this anymore. He consented to the personal jurisdiction of this court because this defense must be asserted before filing an answer. This is what I said earlier. Failing to do so amounts to waiver. Yeah, and I think that Dean may have waived by filing his answer. Asaf filed his answer on August 4th. His answer asserts several defenses, but not a lack of personal jurisdiction. He waived the defense and consented to this court's jurisdiction. Motion should be denied. And this is actually the correct legal argument. Now, will the court give him leeway because he's a pro se defendant? I don't know. But this is the correct legal argument here. First thing Preston's gotten right in this whole fucking thing. Pick the fight in Texas, should be settled in Texas. This is the same shit. This is the same argument. They've just copied and pasted it. Exact same stuff. Same thing. Complaint states claims against Asaf. Remaining arguments fail to pass muster. It's all the same. What? We got some more stuff. It's not established a statement cited the cancellation. Launched his first comic on March 1st with projected sales of 5,000. Wait. No. You don't get to do this. You fucking failed at the onset. It's his first comic. Why are there projected sales of 5,000? What market research into John T. Lamont's brilliant drafting, authoring, illustrating suggests that this is a $5,000 Kickstarter? On the same day the comic was launched, they began an intense campaign of denigration and vilification of John Lamont, calling him a pedo, Comic book sales immediately stalled. Some prospective customers refused to support the campaign, citing allegations of pedophile, poor sales force. This doesn't actually say what they think it says. This says that other people looked at the campaign and said, kind of looks like a pedophile, bro. The problem with this is the prospective customers didn't mention Dean or Vicky. Now they say, DA Talk said you're a pedophile, so I'm not going to buy it. Bam, you got it. You got it. Or if you could prove that the customer saying you kind of look like a pedo was watching a DA Talks live stream. You haven't done that. You haven't asserted anything to tie their statements to these customers refusing to support it. In fact, the reasonable conclusion is that everyone's opinion is that you guys look like a bunch of fucking pedophiles. That's the reasonable conclusion. I'm not saying that you are. I'm saying that it's reasonable to think that everybody who looked at that campaign went, except for 4 weirdos, right? 4 weirdos were like, oh, I want this pedophile comic. And everybody else said, God, you guys kind of look like pedophiles and child pornographers, and this is gross, and didn't buy it. That is the most reasonable conclusion. But what is an unreasonable conclusion is to say that an untested first comic had projected sales of 5,000. You have no basis for that at all. What? Who is John Lamont? Why would anybody be like, oh, you know what? Yeah, I'm definitely going to back that. Did you have a mailing list? Do you have anything to support that prior to March 1st when you launched the comics? You had projected sales? No, you don't. And God, you almost want this to go to trial, even though it's over such trivial amounts of money that it would be embarrassing. But you want, you get the fantasy, right? That either Van Skyver or Dean or whatever would hire an expert in marketing to come in and just obliterate the fact that there are projected sales of $5,000. They'd be like, based on what? What has John T. Lamont done? Does he have a social media presence? Can you show that there's anybody who is excited for this pedo comic? Now, have you done market research into other pedophile comics to find out how those do? And then you determine that the $5,000 is a reasonable amount for pedophile comics? Like, those are the questions you got to ask. That's the beauty on cross-examination. You would just hammer this person. You'd hammer him. So, how many pedophile comics did you look up? Oh, I'm sorry. How many definitely 5,000-year-old sex demons that look like an 8-year-old comics did you look up? How many of those did you look up when you were writing your pedophile comic? Is that how you determine the $5,000 amount? Or did you just determine it off of nothing? You know, it's not going to work for John Lamont and Preston in this instance. They have no basis for saying this is a $5,000 campaign. Or any number campaign. It's his first one. These aren't ongoing characters. These aren't characters that people are like, oh, yes, I really want to see that girl get reamed out by a sex demon again. No one's doing that. They have no idea how this comic's going to do. The complaint is you asked to have statements cause the cancellation of the Demonatrix campaign. What statements? What statements? They're trying to muddy the water here. The judge's clerk in federal court is probably not going to be fooled by this. Judge's clerk in federal court's going to go, what statements though? Because all of his statements were after this. Like the statements that you've cited are later. So what statements? Lamont has 74 followers on Twitter. Oh yeah. By the way, guys, the rule for monetary support is something like 1%. It's somewhere around 1%. 1% of followers are likely to monetarily support you. On Twitter, it's probably lower. Allegations of the complaint are insufficiently specific. That's correct. They are. Cannot properly defend themselves, and they have no idea when and where to look to ascertain the validity. But the complaint specifically alleges that the statements were made between March 1st and May 2nd. It's pretty specific. They were made within 2 months. Just then. Which, where, when? Okay, this is a nonsense filing. It's not even worth reading because it's mostly the same legal arguments that we just read. And then the fact specific stuff is fucking stupid. So I'm not going to keep reading it. Let's do this. Final document we've got. This is not actually up yet on Pacer. This is the reply from Ethan Van Skyver. You can't find this anywhere else yet. Exclusive access. Breaking news right here. Here we go. Defendant Ethan Van Skyver's reply brief. Defendant Ethan Van Skyver replies to plaintiff's opposition brief. Mr. Van Skyver will not repeat arguments from his principal brief, filed August 4th, but will only address new issues raised by plaintiff's opposition brief. Mr. Lamont's case must be dismissed. John T. Lamont is asserting a cause of action against Mr. Van Skyver, yet the alleged defamatory statements spoken by Mr. Van Skyver do not mention Mr. Lamont. Plaintiff's opposition brief disputes none of this and no rationale. Oh, there's no E. Oh, you said rational. It's supposed to be rationale. Typo. You lose, Ethan. Oh, get wrecked. Where's your E? No E from Uncle Ethan? Oh, my God. Shut it down. No rationale is offered to rescue Mr. Lamont's cause of action against Mr. Van Skyver. Therefore, Mr. Lamont's case against Mr. Van Skyver must be dismissed with prejudice, except you forgot the E's, so you lose, sucker. Plaintiff argues that a single minimum contact, his Texas residency, is sufficient for personal jurisdiction in Texas. This will be interesting because I wonder if it sounds like what I just said. I haven't read this yet. I've never seen this before just now. And it's important to note that what I said was the other cases were distinguishable, specifically the one because they literally contacted a Texas employer on Facebook. But yes, they haven't shown that the actions are actually directed to Texas, and it's their burden. Parties agree that personal jurisdiction, if present, must be specific personal jurisdiction, and accordingly, the plaintiff must properly allege Mr. Van Skyver has minimum contacts with Texas, directly relating to the two alleged defamatory statements. That's what I said. It's his burden. It's Preston's burden. In the following passage, plaintiff lists all minimum contacts he alleges Mr. Van Skyver has with Texas. Van Skyver expressly aimed his defamation at Texas. He knew that Poulter lives and works in Texas. When he called Poulter a pedophile and child pornographer, he knew and intended that the brunt of the harm would be felt in Texas. Under the ruling Calder, that contact alone is sufficient for this court to exercise personal jurisdiction over him. I expect Ethan's lawyer is going to ream him out, and he'll like it. The briefs each have 2 series of page numbers. All citations to briefs will be used in the numbers found at the bottom of the page rather than numbers generated by EFS located in the heading. So there you go. We note at the outset plaintiff is employing a bit of puffery. There are 2 categories of contacts with the forum state defined in defamation cases. Defamation expressly aimed at the forum state contact and defamation in which the brunt of the harm is found in the forum state. See below. But here, plaintiff is deriving both types of contacts from a single piece of information. The alleged knowledge that Mr. Poulter lives in Texas. Thus, plaintiff's complaint alleges only a single contact with Texas, his own residence here. Captain Kerfuffle says, someone seems to have used a Phoenix Wright bot on your Twitter thread about Kyle's prosecutor being a shit, and the result is pretty good. Recommended watching later. Oh, no. Oh, that's good. Maybe we'll bring it up. Okay, knowledge of plaintiff's residence is not a contact sufficient for personal jurisdiction. Plaintiff misrepresents Calder v. Jones. Thank you. Thank you. Uncle VS. Star VS, very disappointing. That's very good. In Calder versus Jones, actress Shirley Jones brought suit in California claiming she had been libeled in an article published by the National Enquirer and its editor, Ian Calder. The U.S. Supreme Court held that sufficient minimum contacts existed between the National Enquirer and California to support personal jurisdiction because California was the focal point of the story and California is where the brunt of the harm was suffered. California was the focal point because information contained in the article was obtained through phone calls to sources in California and calls a reporter made to Mrs. Jones's home to elicit contents. So California was also the location in which the brunt of the harm was suffered. It is the state in which Miss Jones lives and works, and in which the National Enquirer has its largest circulation. National Enquirer publishes a national weekly newspaper with a total circulation of over 5 million. About 600,000 of those copies, almost twice the level of the next highest state, are sold in California. In the present case, plaintiff relies upon its so-called effects test, or the rule in Calder, to justify his claim that personal jurisdiction in the forum state can be found merely on plaintiff's residence. He characterizes Calder with brazen inaccuracy. The share of the audience in the forum state is not relevant. The defendants in Calder published their statements in a national magazine that had only about 1/10 of its circulation in California. The actual language of Calder cited above does not contain a rule of Calder, favoring personal jurisdiction based solely on the location of the injury, and unfortunately for plaintiff, numerous cases hold precisely the opposite. That foreseeable injury alone is not sufficient to confer specific jurisdiction, absent the direction of specific acts towards the forum. I would have, this is a stylistic criticism. I would have pointed out that the fact that California also happened to be the highest circulation state, more than twice the next one, I would have just recalled attention to that and said, it's this perfect storm of everything in Calder that adds the minimum contacts. And I would also physically harp on the fact that the National Enquirer sent physical copies into the forum state for consumption by the forum state's residents on a regular basis, and specifically in this instance. Whereas in YouTube, there is no way to physically send a copy of the video to anybody in Texas, and Poulter and Lamont have not asserted even one Texan other than themselves who saw the live stream. To me, that's a really important thing. Not only did you not direct it to Texas, but Poulter, 750 people, where are they from? Can they show that even one Texas resident watched the video? They can't. They don't even know if the video was watched in Texas ever. And here they are asserting that the bulk of the harm was caused in Texas. That's what I would have included. That would be a little bit different. Maybe they include it later. I don't know. But that's the one thing I would have added here, is that they haven't shown even one person in Texas consuming it, where we know from the National Enquirer case, Calder v. Jones, that several thousand to 100,000 Californians would have purchased the National Enquirer. In fact, all 600,000 copies would have been purchased by their distribution partners in California. So all of those, even if there are no California residents buying each individual copy, 600,000 copies were purchased specifically in the state of California. Plaintiff represents Revel versus Lidov. No kidding. According to plaintiff, Mr. Van Skyver picked a fight in Texas, so it's reasonable to expect that it's settled here. But despite its encouraging quote, Revel's holding is directly contrary to plaintiff's interests here and can be cited as precedent in favor of defendant Van Skyver. Uh-oh. Oh, you're right. Revel is 2 L's. Shit, you only got 1 L. Oh no, you got 1 L here. You got 2 L's there. Ethan, your attorney needs to be fired immediately. I'm Batman of attorneys. You think you can keep the L's away from Gotham, but I'm here to bring the L's straight to you. You can't keep the L's away from me, lad. I'm going to bring the L's right to your doorstep. I'm going to bring the L's to your filings. I'm going to bring the L's to your feelings. And I'm going to bring the L's to your funeral. In Revel, an article was posted on a publicly accessible bulletin board maintained by the Columbia University School of Journalism in New York City. The lengthy article singled out Texas resident Oliver Buck Revel for severe criticism over his handling of the terrorist bombing of Pan Am Flight 103. which exploded over Lockerbie, Scotland. Oh, guys, we've come full circle. We have come full circle here. So the Lockerbie bombing, if you guys don't know, Mark Wade was sued by your boy Zach, right? Richard Meyer. The attorney who first started representing Mark Wade was a fucking weirdo named Mark Zaid, a shit attorney by any account I've ever seen, and a complete nut job. Also a liar. And I know he's a liar because he lied about me, and I proved his lie on Twitter and BTFO'd him for the entire world. He's a fucking liar, and fuck you, Mark Zaid. I hope you catch gonorrhea. That being said, Mark Zaid is the attorney who negotiated the settlement on behalf of the American parties in the Lockerbie bombing. There, we've now come full circle. The Lockerbie bombing is part of Ethan Van Skyver's case. Ethan Van Skyver helped out your boy Zach. Mark Zaid represented Mark Wade against your boy Zach. We've done it. Going so far as to accuse Revel of complicity in a conspiracy and cover-up of the bombing. Mr. Revel. It's supposed to be 2 L's on all these. Oh, God, you're losing the case so hard right now, Ethan. Insisted on suing in his home state, Texas, despite the fact that the article contained no reference to Texas, did not refer to Texas activities of Revel, was not directed at Texas readers any more than readers in other states, and Texas was not the focal point of the article or the harm suffered. Unsurprisingly, the trial court granted the New York defendant's motion to dismiss for lack of personal jurisdiction, and after Mr. Revel appealed, the Fifth Circuit affirmed the trial court. Oops. The court will recall the present case is closely analogous. Defendant Skyver was a guest on a YouTube live stream conversation which did not reach out to the forum state for content, did not discuss any activity in the forum state, and unlike a magazine, was not sent to cause injury to anyone in particular in the particular state. Oh, there we go. Right? Perfect. That's what I was talking about. Rather, it was sought out by about 750 listeners who found a video on a particular YouTube channel. Indeed, for all we know, Plaintiff Poulter may have been the only Texas resident who saw it. Hey, it's like lawyers think in the same way. This is great. I love when I get to make an argument and then I see it pop up in the exact document I'm talking about. That's fantastic. That's what I would have done as well, either in this section or the other section, and this is great. Finally, we note that the main injury, alleged with 7 citations in the complaint, was the cancellation of the comic, but this injury would be felt not in Texas but in Florida, which is the home state of the comic's author, co-plaintiff Mr. Lamont. Other cases cited by plaintiff are no help. Plaintiff cites cases in which personal jurisdiction was justified, but they are inapposite. It means they don't apply here. In each, the defendant had directly contacted the forum state, and that contact gave rise to the cause of action. Lewis versus Fresney, telephone conversation directed to the forum state contained the fraudulent statements that led to the cause of action. We saw this in Richard Meyer's case. That's what it was. The conversation was directed to the forum state. They called Texas. Wien Air Alaska versus Brandt. Calls, letters, and faxes whose contents contained fraudulent misrepresentations were at the heart of the cause of action. So again, you've got calls, letters, and faxes going to the forum state. Hallbecker versus Hall. Defendant publicized defamatory statements in the forum state by contacting plaintiff's friends, family members, and employers via Facebook messages and emails. Nailed it. Nailed it before I read it. Nailed it after I read it. U.S. Trade Association versus unidentified parties. This is the SOSA or whatever. Defendant's alleged defamatory statements refer to plaintiff's conduct in the forum state, and defendant used sources in forum state for the alleged facts. Plaintiff cites 2 other cases, but inexplicably they favor the defendant. In Fielding versus Hubert, no personal jurisdiction was found for an alleged defamatory series of articles, despite the fact that several copies were purposefully sent to the forum state, Texas, and despite the use of Texas sources for background research. This is because the clear focus of the articles was outside the forum state and knowledge of harm in the forum state was conspicuously lacking. Interestingly, Fielding explicitly held the plaintiff's mere residence in the forum state is not sufficient to show the defendant had knowledge that the effects would be felt there. Yes, Very good case. Similarly, I'm glad Preston cited it. Similarly, in Clemens versus McNamee, the baseball player Roger Clemens, a Texas resident, sued in Texas. Remember when Roger Clemens played for the fucking Astros? That was a ways back. Sued in Texas over alleged defamatory statements which were published by every national news service and in every major newspaper. Nevertheless, Fifth Circuit affirmed the Texas District Court's dismissal for lack of personal jurisdiction, despite the defendant's 35 trips to Texas, because the focal point of the statements alleging Mr. Clemens used performance-enhancing drugs was not Texas, but concerned only non-Texas activities, the delivery of the drugs to Clemens in New York and Canada. Plaintiff argues the Zippo spectrum is not determinative in internet defamation cases where the defaming defendant does not operate the website. Plaintiff is wrong. That court, wrong. That court pointed out the analysis in Zippo Manufacturing Company versus Zippo.com had been applied in Revel to the defendant who posted allegedly defamatory article on the website of another. The court questioned how Zippo would apply to the website operator. Since Mr. Van Skyver is not a website operator, this discussion is irrelevant. Indeed, Zippo is routinely cited in several defamation cases. Under Zippo, because YouTube is a passive website, the context of that website will not be sufficient to establish personal jurisdiction. Boom. Fucking obliterated. Annihilated from orbit. Plaintiff does not dispute that when actual images are displayed, the comments on the images are opinion and cannot be defamatory. Plaintiff is faced with a line of precedent that appears to require dismissal for failure to state a claim upon which relief can be granted when the underlying basis for an alleged defamatory statement is disclosed, allowing the public to see for themselves. The First Amendment protects that statement as a non-actionable opinion. So here we go. These got a bunch of citations on this. The live stream containing defendant Van Skyver's alleged defamatory statements first displayed the image which was the underlying basis for the statements. This is really interesting. I haven't read these cases, but I'll have to do some research on this because this is a fantastically interesting way. We can show you the thing that we're forming the opinion on and then give you our opinion, and therefore you can draw the opinion. It can't be, I guess the theory is it can't be a lie if you allow the person to see it, right? If I show you, look, a king of spades, but I say, this motherfucker always draws a queen of spades. You know that that's a king of spades. So I guess, how could it be a lie, right? To address this issue, Plaintiff Poulter quotes a truncated version of the alleged defamatory statement, which Mr. Van Skyver distinguished Mr. Poulter from an individual outed as an actual, child pornographer or pedophile. Mr. Van Skyver's full statement was this. Rather than quote the statement in full, plaintiff represents the statement as follows. That is interesting. You don't want to be caught doing this, by the way. Don't paraphrase when the statement in full is shorter than the paraphrase. So here's the statement in full. Here's the paraphrase, which is longer than the statement in full. Terrible plan. Thus, plaintiff truncated Mr. Van Skyver's actual statement and replaced it with his lawyer's words associated with. Mr. Poulter thus converted a statement distinguishing Mr. Poulter from an actual child pornographer into one which associated Mr. Poulter with an actual child pornographer and pedophile. Mr. Poulter argues the above somehow implicates Mr. Van Skyver, despite the fact that he showed a few images, he nevertheless clearly intended false assertions. This misleading out-of-context quotation to the record is no substitute for legal argument. Indeed, it is a tacit admission that Mr. Poulter has no valid legal argument and the case must be dismissed. Allegations presented in the complaint have been tacitly withdrawn, showing the original allegations were false and misleading. Plaintiff Poulter originally pleaded that he was the owner of the trademark Comicsgate and promoter of Comicsgate, that Ethan Van Skyver claims the Comicsgate trademark is no longer of interest to him, and that Mr. Van Skyver would do whatever he had to do to interfere with Mr. Poulter's comic business. But as defendant presented his side of the story in the briefs, Mr. Poulter's case is falling apart. The Comicsgate trademark was not owned by Mr. Poulter. He merely filed an intent to use application and has filed a cancellation proceeding before the U.S. Patent and Trademark Office, attacking the pre-existing registered Comicsgate trademark owned by another. It is now clear that Mr. Poulter started this dispute. He applied the Comicsgate trademark to a comic containing pornographic images of very young women without the consent of Mr. Van Skyver. Mr. Van Skyver's alleged defamatory comments were merely the understandable anger at the unauthorized use of his trademark. Conclusion: for the reasons above, Ethan Van Skyver moves this court to dismiss him from the suit. I actually would not word it this way. I'll be critical of one thing on this complaint. The rest of the reply is really, really, really good. And this isn't bad. I would just word it slightly different, personally. I would not say his alleged defamatory comments were merely the understandable anger at the unauthorized use of his trademark. I would say Mr. Van Skyver's allegedly defamatory statements were in response to the unauthorized use of his trademark, but still constituted a legally protected opinion about information which was shown to the public from which they could draw their own conclusions, or something of the like. I would not say understandable anger in this one. Unless, because they haven't, one defense to defamation is rhetorical hyperbole. They haven't actually raised rhetorical hyperbole anywhere else in the filings. And to me, I would hold on, like if you haven't done the rhetorical hyperbole argument so far, I wouldn't try to kind of introduce it here without the specific calling out of rhetorical hyperbole. Again, a stylistic choice. I think that by and large, this reply is very, very good, but and it nails them on the law. It nails them on the case citations. This is just, I just wouldn't do understandable anger because understandably angry people can lie. Understandable anger is not a defense to a defamatory statement, for example. It can be a reason why someone would defame someone else, but it's not a justification for it. So that's the reason I wouldn't have included this particular line. I would have modified it mildly to go back to the defenses that are already asserted. But all in all, a very, very good brief here. Very, very good. Scott Houtman appears to be an up-and-up fantastic lawyer. He and Thomas Adair have done a great job so far. And again, it took a lot to nitpick the stuff in this document. I mean, this is one of the, this is like the lightest nitpick you could make. They made one statement that went a little bit beyond what I would do. I mean, come on. The rest of their document is probably better than I would write. So let's be honest about what's going on. This is a good brief. Very good. Very, very good stuff. So thank you to Ethan for sending that. I think it's a great brief. We'll see, we'll see how this goes. I have a feeling this case is going to be dismissed on personal jurisdiction grounds in general for Ethan. It should be dismissed. Like maybe the judge will just dismiss it on 12B6 anyway. Maybe the judge will like lob an underhand pitch over the mound like this is softball and say, we're going to actually accept jurisdiction, but we're going to dismiss it for 12B6 with prejudice. And maybe they'll do that. I don't know. But against Ethan Van Skyver, definitely should be dismissed for lack of personal jurisdiction. Against Dean, he technically waived personal jurisdiction. He waived it. So then it goes to 12B6, which is fine. I still think 12B6 applies in Dean's case. All right. Now, we've got some super chats to read. And then we're going to wrap up. People have asked me, am I doing a movie or game night tonight? Guys, you're going to hate me. I'm going to skip Twitch, and here's why. I'm going to do a Locals exclusive stream. Locals exclusive stream instead of Twitch tonight. One, because I skipped movie night last night due to the internet going down. Two, I don't want to make an imbalance between movie and game night skipping. Three, because I was going to do a hot tub stream on Locals for the past 2 nights. I will be doing a Locals stream tonight, a movie stream tomorrow, and then we'll figure out what's going on. So we're going to be on Locals. We're going to be on Locals tonight. And by the way, shameless grift, ricadalaw.locals.com. Come join it. I don't advertise it enough. I really should. You can join Locals for free and get access to all of the, they're way better at sending out notifications for streams. I post every stream on Locals, and the notification goes out immediately. None of this YouTube algorithmic notification bullshit. If you join Locals, you will be notified when the stream link is live. Every single time. You get early access to videos, all of that stuff. You also get access to very exclusive content like hot tub streams, or as I like to call them, thought tub streams. And tonight is a thought tub stream. They're only for Locals members. The Local streams are only for Locals members most of the time. Not all of them, but most of the time they are. So if you want to join Locals, you can join for free to get the notifications. If you want to get access to the exclusive content, which is a little more behind the scenesy, I post pictures of food and stuff like that, and videos of food. That shit's all on Locals. Plus, with Locals, you get access to the Discord. And if you want to be in the Discord, you can do that there too. My mom's basement hot tub. No, my hot tub on my deck, Sheila. I got a nice hot tub out on the deck, and that's what we're doing tonight. I'm gonna sit in the hot tub. It's like 40 degrees outside. It's fucking just barely above really cold, and it's perfect hot tubbing weather. So there you go. That's that. So if you guys are Locals subscribers, we'll get that started in a little bit. But first, we've got a lot of chats to read. And by the way, shout out to Legal Bites, who's been in the chat the whole time. Or not the whole time, but a significant amount of time, which is great. Love to have Legal Bites here. Curious what her opinion on these filings are. Legardicus says, misread the title out of the corner of my eye. I thought it said EVS pegging poultry for real this time. Worse, even though I read EVS correctly, my sleep-deprived brain conjured an image of DSP. I blame Tim Pool's weird obsession with chickens. That's fair. Curtis says you can tell Nick is from the frozen north. 40 Fahrenheit is just barely cold to him. Oh, buddy. When you I'm getting in the hot tub. You can get in the hot tub at like -10. As long as the wind isn't blowing. If the wind's blowing, it'll actually blow mist onto your beard and freeze it. That's fucking cold. But hot tub streams are great. I'm actually mildly excited for winter because I love getting in the hot tub when it's like 10, 20 degrees out. Here's the thing. I have a 4-season porch. That's my TV room, the sunroom. You guys have seen it. That thing has a giant fucking heated floor. And I turned it up to maximum before coming down to the show. So when I go in that room, I'm going to melt. But, despite melting while in the room, when you go in the hot tub and you come out of the hot tub, you gotta get in that warm ass room to dry off. Because that's the trick. You get nice and warm in the hot tub for like an hour or whatever. And then when you get out of the hot tub, you're warm. Your body temperature is up. And then you can go into the hot floor room and dry off and not be freezing. Not be chattering like a fucking weirdo. It's amazing. It's amazing. I really, really, I hate winter with all of my fiery passion. I fucking hate winter. But now that I have a hot tub, that's the only good part of it. Oh, you do the Wim Hof thing, Don the Gamer Guy? Wim Hof's a weirdo. I can't do a hot tub watch party. I don't have that set up. I actually just ordered a new webcam to do some mobile stuff to do stuff like that. From Indiegogo. I ordered the Lumia 4K webcam, which has like bokeh effects and shit, and AI bokeh effect things built in. We'll try it out. Lumia is a pretty interesting brand of cameras. They do some pretty cool stuff. I'm interested to see what their webcam does. But I did just order it, and I'll let you guys know when I get it. Facefucker 4009 says, comedy is only hard when your crowd is full of art-hearted Americans. I likes comedy. I is smarts. Kermit the Frog says, glass? Who gives a shit about glass? Oh, you're in charge? Well, I got some bad news for you, Dwayne. From up here, it doesn't look like you're in charge of jack shit. I'm the asshole. I'm not the one who just got butt-fucked on national TV, Dwayne. What the fuck? Who's Dwayne? I don't know what that even means. Frega Boom says, gonna watch this on the replay, brother Nick. Gonna be epic. What's up, guys? Frega Boom. You gotta check him out. Couch Doodles. Dan Frega. Comic artist extraordinaire and all around chill and good dude. Make sure you go check out his channel, Frega Boom. Fraga Boom! Exclamation point. He's a good dude. He's wildly talented, and his experience is bar none. I mean, like when you see this guy's resume, you're like, holy fucking shit, what have you done? This guy is doing great stuff. Great stuff. He's a good friend. And you got to check out his channel. He's amazing. Also, I am going to be killed in his comic. Gal Iron Runner says, what's your take on Legal Eagle's video on the mandates? He says it will be legal. If his views are normal, Dems good, Republicans bad, as always. I haven't watched Legal Eagle's video on the mandate. Maybe I'll do a response video to it because he's a fucking douche. An absolute douche. Death Wish. I do have a heat allergy, but I also get monthly injections and take daily pills to fight it. That's why the hot tub works. Mario Carter 13 says, shocking. Wouldn't have pegged him as that kind of guy. Stephen Cooper says, here's 5 for being on time for once. Critical Gaming says, Nick, I just want to say thanks for answering my DSP question on Twitter this evening. Oh, you're welcome. Crusader says, Don Rickles, Shamalamalama. God damn it. Shamalamalama, Kamala, and everyone's sucking sand. Oh, what a fucking great. God, Dirty Work is like the best movie. The best movie that exists. Don Gamer Guy says, one of those 5-minute reactions that takes 3 hours. Nah, probably like 30 minutes, though. I did a great Legal Eagle takedown video of his takes on Trump's pardons. I annihilated him. And I had so many Legal Eagle simps come into the fucking comments. It was beautiful. You got to check it. You got to check it out. Krusty Zenitko says, we all know she, as well as her boyfriend, got ate by a skinwalker. The skinwalker stole his skin and is now on the run. Taco Jones says, Tim Pool, the Beastmaster. Eldon Bainling says, Tim Pool's haircut is greater than Nick's haircut. Fact check me. No one's ever seen Tim Pool's haircut. You liar. It's all under the beanie. MGTOWN Podcast. Hey, Drex. We got to talk, man. And we got to talk about this fucking Twitch thought. Speed dating her chat section. Speed dating her chat section. Oh, it's Tim? Oh, never mind. I don't want to talk to you. WMMA. I'm just kidding, buddy. How you doing? I hope you're doing okay. Hope everything's going well for you. WMMA Scene Now says, Beanie Simps are almost as insecure as Tim about his not-so-secret baldness. Aurelianus says, is it a Tim Pool hate crime if I buy a ratty beanie from Goodwill and burn it in some esoteric ritual? No. I mean, yes, but no. Fan Advocacy Network says, I'd rather speed date a bullet than a Twitch thought. Popcat Zoo says, have you had Basil Hayden's 2x2 ride? No, I've not. Drex launches a merch store tomorrow to Patreons and subscribe stars before the general public. Cool. Good. I'm glad. That's great. Eldon Bainling says, Nick Krigler once on. Let him on, bro. Come on, man. No. Krigler couldn't derail this fucking shit. Sheila Alien says, give credit where due. I exposed Peggy. That's great. Sheila, you are a horrific degenerate for just watching pegging porn like normally. Like, be a good chick and just watch lesbian porn like the rest of us. What are you doing? But she's out there doing yeoman's work, watching pegging porn and coming across Pegston, which is terrifying. Sheila, I have to ask, why are you watching pegging porn? Oh my God. Cartman54 says, I found some Japanese plum Gekikan at Total Wine and More the other day in the sake aisle. And it tastes great, around $15. Would recommend. Cheers. Eldon Bainling says, EVS's haircut is greater than Nick's haircut. Changed my mind. EVS hasn't had a haircut in 35 years. Wrestler Town says, why are 100% of perverts good at drawing? Sir YouTube says, what's your opinion on Russell J. Gould? I have no idea who that is. Yethna P says, what the hell? You don't have Cecil in here doing the voice? No, I don't. Eldon Bainling says, Fly Coon's haircut is greater than Nick's haircut. Political fact. Look, I'm not going to take hair advice. I'm not going to take hair advice from an Indian from India who all have like weird flowing manes. Sheila Alien says, Nick, I was literally joking because I thought it would be a funny story than I was snooping on him. Sure, Sheila. Uh-huh. You're like, yeah, ram it, girl. Get it. Get that out. We know. You can't walk that back now. Eldon Bainling, I know your haircut because every Indian man's haircut is exactly the same. Stop it. Amateur Ant says, not so fun fact. Lolita was a movie made in the 90s about pedos having sex with a 14-year-old girl. Looked it up on Google. It is. Bogus Fortune says, time, money, and stress, or what lawyers call billable hours. Deep Service is important. Who are the four backers? All in all, just another peed on the. All in all, it's just another peed on the wall. I got 72 letters left, so this is what you get to maximize my utilization of. The suspense. Stephen Cooper says, internet's getting pegged. Dorby says, hail Ethan, human sunbeam, his royal pinus. Natalie Braithwaite says, Hans gets the Flammenwerfer. Talons here says, I hope you remember what you did for the 21st of September in the 21st year in the 21st century, because you'll need to remember in order to sing the song by Earth, Wind, and Fire. Do you remember? 21st night of September. Levi King says, just draw a farm, bigot. Mandy Carvicia says, why you call us dummies, Nick? I didn't call you dummies. Maybe I did. Balaam's ass says, I live in Texas and Ethan did not contact me. Oh, there we go. We just get every other Texan to send a message that says Ethan didn't contact them. Just every other one. Like 35 million messages. Eldon Bainling says, call us dummies in Trump voice, Nick, do it. Look, I've been around the internet a little bit. I've done some browsing in my browser, Chrome, Edge. I've used all browsers. Netscape is probably my favorite. And you go around, you do these things. You find these websites, you watch these things, you watch live streaming video. It's a new thing that's out there. It's kind of like television, but it happens online on the internet, which is a wonderful device created by Al Gore. Put some pipes together underground and suddenly everyone's connected. A very good thing that he's done. Lately, he hasn't done as many good things, but this was a good thing that Al Gore did. The internet. But by the way, you go on the internet, you find a various address, you put it in kind of like you're going to drive to it or whatever, and you get digitally transmitted to it. And one of them is a YouTube channel I've seen called Rakita Law. Rakita Law, I think it is. Some guy in Minnesota. I don't know. He seems handsome, well-spoken, sometimes drinks a little bit too much, but that's okay. Look, his audience, though. I was in the chat. I was watching the chat. It's an interesting chat. It moves a little bit quicker than some chats, a little bit slower than others. Sometimes they make donations and other things, but kind of dummies. When you think about it, I've seen a lot of dummies. I've run across dummies in my life, and like Joe Biden, for example. Mike Pence turned out to be a dummy. Kamala Harris isn't a dummy, but she likes to put the dummies in her mouth and other things. But the dummies in the chat, they were all over the place. It was weird. They didn't even follow what was going on. It's like they had their own thing going. I don't know. I was enthralled by the host, and the dummies in the chat were talking about their own nonsense. Something about balls. No balls. Of course there's balls. There's balls everywhere you look. You got balls all over the place. You got basketball, baseball, football. Okay, sorry. Levi King says, don't buy a farm, follow your principles, and buy a wallet. Terrific. Michael Dixon says, I did not kill 100 orcs in D&D. Will you be my lawyer in this case? Yes. Amateur Ant says, Ridge wallets work more efficiently and safely. Up your rump. Just ask Peggy. Durna1804 says, maybe he extrapolated his sales estimate from the sex offender registry. Oh. Anton Shutter says, not law related. No need to read. Just saw a trailer for a movie called Handjob Cabin. Don't know if it's a real movie, but would recommend watching it. Amateur Ant says, the more I'm hearing this, the more I think Peggy is using the Chewbacca offense defense. Amateur Ant says, go back to Ford versus Montana and ask yourself, if someone sells a product to Texas, would this BS apply? Okay, so you're asking if because Ethan sells products that go to Texas, no, because Ethan's products aren't directed to Texas. The difference between Calder v. Jones and what Ethan does with Cyberfrog, right? Which is interesting that they should have argued this because it would be an interesting case. But the difference is simple. National Enquirer has business partners in California, and they are going to send a predetermined amount of issues to California every single month, week, whatever, however often they're published. They're going to send 600,000 copies to California at the time of Calder v. Jones. Every single time, they're going to send 600,000 copies. That's a lot. Ethan's deliveries of Cyberfrog to Texas are different in two ways. One, they're not related at all to the alleged defamatory statements made against Preston. But two, the other thing is Ethan will not send a single issue of Cyberfrog to Texas unless a Texas user asks for it. And that is the very, very different thing. That is a very, very different thing. A Texas citizen has to reach out to Ethan to get a copy of Cyberfrog. There's no bulk deliveries. Okay, he asked me not to show anybody. Guys, his haircut is literally every Indian guy ever. I'm right. I'm right. He asked me not to show anybody. Here's what I'll do. I got an idea. I can do this. I got you, Baneling. Look at this. I got you. No one on earth can identify you by this picture. I promise. Don't worry, brother. You're safe. Here we go. There it is. Look, it's every Indian guy's haircut that I've ever met. It's all the same. guy. Oh shit. The hair just DM'd me and it says open Bob. It says open Bob and show vagine. I don't know what to do. I'm trying to tell, I'm messaging the hair back. I'm like, bro, I'm not a woman. I'm a guy. And it's like, no, please open Bob, show vagine. Also, your computer have virus. Please give access to Google Photos. It's very weird. I don't know why that happened. God damn it. Nix Hex says Zayd is also a lover of Nickelodeon girls. How dare you, sir? They're Disney girls. Zayd is a lover of underage Disney girls. And that is his YouTube history. His YouTube history. It's not me. I did a video on it. Other people did videos on it. You can check it out. These goddamn underage kids, weirdo. Poorly Redacted says, did you know Tim Pool plays guitar for his chickens? I did know that. I did know that. Fighting Slug says, in San Antonio, my thermometer says 81. Damn. Amateur Ant says, Locals is great, run by a free speecher that doesn't put up with cancel culture. I agree. I agree. They have no, like, I was talking to a Locals person. I was like, what about these types of jokes? Right? Like, because my chat's a little spicy, and some of them will make a joke about the Jews. Some of them will make a joke about the blacks, for example. And they're like, we don't care. We literally don't care what anybody says. Crusader says, congrats to Cody Byer for fully funding Cloud Scratchers with almost 2 weeks left to go. Yes, Cody came on here, and many of you stepped up and helped fund Cloud Scratchers. It's really a great thing to see independent creation being supported, and I'm glad for Cody. I hope he has a lot of success. Mandy Carvicia says, any Recato Law pillows for purchase? Not yet. Heinrich Berndowski says, it's almost as if Lolita, the films, Kubrick's and the 1997 one, are based on the famous Lolita, the book by Nabokov. Yep. Malik Foxon says, I also live in Texas and EVS didn't contact me. Crusader says, Nick, I'm going to tell your wife you were cheating on her with your hot mistress who appeared on stream in your backyard while she was away. Yeah, she's, look, I don't know how else to say it. The chick who appeared on my live stream earlier today that I did was a drop dead hottie. Drop dead hottie. And yeah, you'll have to tell Lady Rackets. I don't know what else to do. Absolutely gorgeous. Eldon Bainling says, I DM'd you my superior haircut. Get wrecked. Tomorrow, VI says, Tim's chickens, egg, or no egg. Andrew Ann says, congrats, you have successfully canceled cancel culture by being part of the Republicans, the Libertarians, and the Independents who stand for freedom. Kulfe 2A wannabe Hunan Muhammad says, but did Bainling's hair get pegged by Pisaki? Oh, he would like that way too much. He would like that way too much. Way too much. You can't let Bainling have any access to any sexual action of Pisaki. I'm trying to save him from her. I'm like, bro, you don't do it. He's like, redhead. No, don't. No, Bainling, no. Don't get on a plane. No, Bainling. Oh God, she's horrifying. All right. That's the show we have today. Bainling, if you don't understand that she will peg you, that's all she will do over and over and over again. And you'll be like, mommy milkers and red hair, and she'll be like, peg. And then you'll be on a website like Preston. Don't do it. Don't do it. Thank you guys for watching tonight. That's all I got. I'm gonna play the outro. I haven't played the outro in a while because I keep getting cut off for being on Streamlabs or whatever. Let's play the outro. And then I am going to go on to locals for a little bit of hot tubbing. Thanks for hanging out. This is a very long stream. Look, these filings, they're interesting to me, but I know they're also really thick and boring for the audience. It's why I've strayed away from doing filings. Guys, I can see metrics, right? Like, I'm not crazy. I know who's really interested in filings, and it's you know, they're not the most captivating things unless they're really particularly funny, and most of them are not. If they're competently written, they're not going to be funny. So that's why I don't do as many filings and try to stick more to issues and conversations around specific things. But thank you for watching through these things and making the shows worth doing. I always appreciate that very much. And yeah, tomorrow we'll be catching up on Russell Greer. Russell Greer's losing case against the Kiwi Farms. I will probably put together a video like I did with Melinda Scott about Russell Greer suing Kiwi Farms. So keep a lookout for that one. It'll take, it'll be interesting to do those. That video, by the way, is something special. It is something different than every other video I've done. And it was a test case. I'll tell you right now, it was a test case for some other videos, and the response to it has been phenomenal. Let me kind of show you. Let me show you how this, why this is such an interesting thing for me. Okay. I'm going to show you the views. Hell, I'll show you everything about this video, how much money it's made and all that stuff. Okay. This is a neat part of YouTube to me. You might not care about this, but I'll do it real quick. Whoops. Here we go. Okay, so here's the performance analytics of the Kiwi Farms video that I did. All right. You can see how much money it's made so far, $254.35, right? There you go. It's got 37.4 thousand views. I've done plenty of videos that have higher view counts, but this is great. Here's the most important thing on this. Here's the view line for this video. Notice what it's doing. It keeps going up. It keeps going up forever. Here is the trend line of videos that I normally do. This gray area is where they go. They go between 15,000 and 25,000 views. That's a typical video. All right. But here's the difference. Most of the videos that I do are really topical for the day that they're released. They're short news subjects, kind of breaking news subjects. This video was a different approach. Here's a complete story. Here's a complete story of a thing. And it's a 40-minute video. These videos are all 15 minutes or less. All of them. Whereas this video is a 40-minute video. And to have it do this is a really encouraging thing. Because being able to do videos that will continue to grow ad infinitum is something that I have not been able to do before. I don't know how to make that content. So this was a video that would do that. It was targeted to try and keep growing on into the future and have more and more people watch it. So with this as the test case, there will be more videos like this that will be done, and not just on Kiwi Farms, but on all sorts of other subjects, like major Supreme Court cases, the complete story of how you lost your gun rights, right? Talking about US v. Miller, the complete story of DC versus Heller, how you got back some of your gun rights. You know, these types of things are things that I want to do, and that was a test case. So thank you guys for watching those videos. You guys watching videos, you have no idea how much it helps. No idea how much it helps to have the viewers initially watch a video. That tells YouTube that it should send it to people who aren't the viewers. It's amazing. So there's more of those coming. They're very encouraging. That it has good performance, and it tells me that if I put in a significant amount of work into a video, that it will over time pay off. That's a good thing. believe me, that's an encouraging thing. So thanks for doing that and watching those sorts of things. All right. Thanks, guys, for hanging out. I'm going to put on the outro, and I will be catching you later tonight on Locals if you're there. And if you're not on Locals, I'll be catching you tomorrow. Also, if you're in the Discord, Live Chat Wednesday is tomorrow. We will be having a Live Chat Wednesday. Remember, no scheduled live streams Thursday, Friday this week. I'll be at a private art event Friday, Saturday, Sunday. I'm traveling there Thursday. I will see if I can do some impromptu videos. I would love to do some videos from the event. It's what I go to with Lady Rackets every year. We get dressed up. I bought her a banging dress, and maybe she'll appear on camera in the dress. I don't know if she will or not, but I can't wait for her to appear in the dress in general. So anyways, guys, I'll catch you guys later. But we will have a normal show tomorrow night, and we will have Live Chat Wednesday tomorrow for the Discord. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour